the same idea.
I'm sorry, guys. Yeah, I'm really late. So let's say hello to everybody. Hey, Lindsay. Hey, Ender. Hey, none of your business. Who else? Ackerman. And that's Lisa. How you doing? So we've got this dipshit here. He's a sovereign citizen lawyer. Why is it doing that? I don't know. Hold on. Let me fix this first off. Uh, Pull that up to there. Bring that to there. Stretch it out. Oops. Shrink that a little bit. All right. Yeah, I made it. Sorry about the wait.
Hello, hello, hello to all the pickles
I don't know why his screen looks like that.
and picklettes. This is your favorite racist cult leader, King
Doesn't he just fucking look like a scumbag piece of shit?
Picklefuck His Excellence, coming at you today. Hi, guys. Today we have a very exciting video, kind of random. The Amnesty Coalition was spoken about in a video. There's a channel here that we're going to be going into. It's called Mitten Cam, at Mitten Cam, and they did a video on somebody who got pulled over with our plates, my plates, however you want to say it. I mean, I think of it as my plates, our plates.
Yes, your fake ass fucking plates that'll get people put in jail for having.
Right. And I posted this on Facebook. It got quite a few people kind of reacting
less.
to
Here's
it.
what others are doing to fix missing broken teeth. The company.
So yeah, I wanted to do a video critiquing this. So here we are. We are critiquing this video. It's Sovereign Citizen versus Michigan State Police. And yeah, 620 comments. We already have a lot of comments here. I wonder if any of our people are here. But anyways, I will critique this. It's got our stuff in it and explain kind of what went wrong and what he should have done right and that kind of thing.
When he says, I wonder if any of our people are here, he means his moderators to block out the people that criticize him.
And I'll probably kind of speed through this. And yeah, I had some people who wanted me to do it, so here we are. So let's get started on this video.
Everyone has been raving about is called Nuvia.
He looks all pink like a newborn, like a baby mouse.
On July 3rd, 2025, just after 7 in the morning, a trooper with the Michigan State Police was patrolling I-94 near Scioto Township. The trooper detected a vehicle traveling at 94 miles per hour in a posted 70-mile-per-hour zone.
Damn, that's pretty quick.
Initiated a traffic stop. Unbeknownst to
I'm
the
going to
trooper,
pause this for 1 second.
Daniel Magoo.
There we go. I lost myself. I don't know what happened there. I'm going to move over here. I think that'd be better. Let's do that.
Was behind the wheel.
Can you stop?
We're not through another car when we get there.
Stop.
So he didn't stop right away, and the cop was like, stop, stop. I mean, if you feel like, you're in an area where, you want to be someplace a little more, safe, maybe get off on the next exit.
Oh, by the way, these are new. Reese's Oreo. They're really fucking good. take place. Oh, it is playing. I muted it.
Continue, forever, and getting off the freeway, it's probably not going to be a good idea. So either pull over right away or find an exit or put your four-ways on at least and pull over partially and stuff. I don't know. I think it was just weird because he was like stopping and going and stopping and going. I think that's kind of what was confusing the officer.
Hello, I'm Trooper Cheney, Michigan State Police. Yeah.
No, it wasn't confusing the officer. It will take a lot more than that to confuse a police officer.
So, first and foremost, as you guys will see later in this video, this pile of shit car, that you call a car, has my plates on it.
Now listen to what... Hold on a second. Listen carefully to what he says here.
Now let's just inspect this car full screen, okay? So
to put things in perspective, he knows that the license plate that he sells people is fucking bogus. He knows this for a fact.
We have, and I know this is going to be brutal, but it's all over my website, it's all over my shit. So, and I've had it on there for a long, long time. So, this is just going into more detail and giving more examples of something I've already been saying for a long time. This isn't anything new. So we have this car. It looks like maybe a Sunfire, a Pontiac Sunfire. We have a lot of these back home in Indiana where I'm from. Pontiac.
It doesn't matter what kind of car it is, man.
Sunfire. You don't see him in California. I believe this is what he's driving. I could be a little wrong, but it's some kind of like very basic sedan type thing, right? That looks like a new one. That looks like something new. Anyways, I can't... Let's go back. Let me see if I can see from the back what he's driving here. Oh, it's a Chevy Malibu? Let's see here. Chevy Malibu. Okay. But it's an older one. It's probably like a... let's see here. 2002, maybe? No. 2006? 2010? Anyways, I don't really know what year it is. I don't think it's the 90s. Anyways, so we're going to go to...
It's kind of weird that it has a Chevy and a Ford emblem on it.
Back to where we were at. Let's go back. Okay.
Can you stop? Hello, I'm Trooper Cheney, Michigan State Police.
So let's go back to the car here. I don't know, for whatever reason, it's just all fucked up. Okay, so first off, we've got paint missing all the way down on the upper half of the door. This looks like a giant gouge, or maybe like maybe he drove up against one of those like parking concrete cinder block things, but that looks like actual damage right there. Okay, and then I can't tell what's going on over here, but you can see all this dispainted. My plate should not be on a car like this. Period. It's fucking stupid, and you're literally bringing attention to yourself. See all this dispainted. My plate should not be on a car like this. Period.
You mean on a car, period.
It's fucking stupid, and you're literally bringing attention to yourself in a way that's actually fucking retarded.
So he's admitting that putting his plate on your car will bring attention to you needlessly, and that's fucking retarded. He's admitting that what he sells to people will get them fucking pulled over. He just admitted that.
So just say that real quick. Okay, let's continue with this video.
Please, you have your driver's license on you? Speed, sir. I had you going 90 miles an hour down the hill back there. I was trying to catch up for a long time.
I can't tell along the bottom of the trunk here. It could be like Bondo. That could be like Bondo or something.
Dude, no one gives a fuck what the car looks like.
Something, or it might just...
He's like trying to like appear to be an expert at shit. Isn't that funny?
Be the light, but that could be like Bondo filling, like poor filling, Bondo filling that's like failing. I can't quite tell what that is, but that's all unacceptable.
I need to see your driver's license. 90 miles per hour. How did you clock them? My radar, sir.
So first and foremost, he's asking for a driver's license. So
yep, that's what he has to provide: license, insurance, and proof of registration.
I don't know why. I don't know what people in the sovereignty space have with this obsession of never answering the questions of the police. Just answer the fucking question. He wants a fucking driver's license. If you ask me, oh no, I don't have one of those. I can't have one of those. I don't qualify to have one.
Yeah, you do. You live in the fucking United States, motherfucker, and you drive a car. You are required to have one.
So what does it say? I'm not going to put the passport card up to the screen because YouTube totally.
So he thinks a passport card can replace the driver's license when you're driving on city streets.
Freaks out, and it's the only videos they've ever taken down of me ever are when I put my passport in front of the camera, because it thinks that I'm like trying to like dox someone and give away their personal information, and it's not mine, and they just like YouTube just like totally freaks out. So if you want to see the video on the passports, you're gonna have to go over to Rumble, and you can find those videos on the amnestycoalition.org. We are currently looking for a new vendor for these. I have a guy who I'm talking to. I have a guy who I've already found new plates for. They're actually going to be embossed. All of the numbers are going to be embossed, meaning they come out. They're like they are 3D. They're really, really nice. So I'm excited to.
Yeah, they're still going to get people pulled over and put in jail. That's what you're doing, dude. You're assuring that people that give you money will go to jail or lose their car. You know, in some states, if you have a bogus plate on your car, it's now criminal evidence, and that you lose that car.
See if they're going to need any adjustments or not. If they don't, I'll probably have a plate supplier for you guys here pretty soon for both motorcycle and car. The passports, we have actually a Pickletarian who's ordered a lot of the stuff. It's kind of a pain in the ass, but I'm hoping to get there when we get there.
These idiots actually think there's a do not detain, do not stop list that you can get on. To avoid shit like this guy piled up, get your traffic injunctions filed with the constitutional officers, Chief Justice, Attorney General, Governor, and Sheriff's Department. This is the only way to get on the do not detain, do not stop list. Dude, you are so full of shit.
So I apologize for that. But anyways, on the back of the passport card, which this may be adjusted slightly for the new versions that we get when we finally get them re-released, bearer is an ambassador at large for a foreign non-governmental organization.
Now listen to this word salad. Listen to this shit.
Slightly for the new versions that we get when we finally get them re-released. Bearer is an ambassador at large for a foreign non-governmental organization, NGO.
No, he's not. No, the bearer of that card is not a foreign national.
Called the Amnesty Coalition. Bearer is on political mission and is not legally a resident of any of the 50 U.S. states of the Union, nor the District of Columbia.
So if you live in the United States, you're a citizen of the United States. Whatever state you live in, this guy is full of shit.
Bearer must display a foreign private motor carrier number in accordance with 49 USC 13102 for
49 USC 49 USC
in accordance with 49 USC 13102
13102 13102. This says, in this part, the following definitions shall apply. The term board means the surface transportation board. The term broker means a person other than a motor carrier or an employee or agent of the motor carrier. Foreign motor carrier means a person including a motor carrier of the property but excluding a private motor carrier that is domiciled in a contiguous foreign country. Nothing in here applies to what you're fucking, the bullshit you're selling, man. Nobody. Nothing. Absolutely fucking nothing. Absolutely fuck all.
For any transportation occurring in the United States. More information on this NGO may be found at www.theamnestycoalition.org. And then we have a signature line.
I mean, have fun in jail, man. That's all I can tell you. Anybody who buys his bullshit, have fun in jail.
Sort of like when you get a U.S. passport and you open up the book and it has the signature section and you're supposed to sign it. No one ever really checked.
Right, you sign that before you get your passport, dumb fuck. You sign the certificate that you send off to get your passport. You sign it there. You don't sign your passport. It's already signed when you get it.
I mean, I'm sure if you fly and stuff, they'll check it.
And it's fucking laminated.
It's sort of the same idea, right? So, and then I have my signature there, and then without prejudice and without recourse are both written there.
Without prejudice? Really? What do you mean without prejudice? What authority do you have? What authority do you have?
Right, and the reason why I put without prejudice and without recourse on there is because there's
because you want to sound important. You want your bogus bullshit to sound important.
So much of the stuff going around now where people are like, oh, you have to sign the same way as your ID, which is like, who the fuck thought that up?
The people that require your signature. See, your signature is a form of identification. It's a form of ID, you dumb motherfucker.
I mean, no, you don't, first off. And second off, fuck you, you know. That's the stupidest fucking thing I've ever heard in my life. But I just put them both.
Well, it would be stupid to a dumb motherfucker like you.
Both on there so that way they don't have that excuse if I ever need to.
See, this fucker should be in jail. This fucker should be in jail for pushing this bullshit, for selling, for profiting on this bullshit. These people, sovereign citizens, are considered by the FBI to be a domestic terrorist group. They believe in paper terrorism, right? If you come after them, if you arrest them, oh, they'll lien your house. They'll put a lien on your house. They're evil fucking people. And this motherfucker is pushing this bullshit.
Sign anything. I've never had anybody tell me that. My God.
The natural progression of sovereign citizen is, well, I don't need to follow the law. I don't have to follow traffic laws because I'm a sovereign citizen. Well, if I don't have to follow traffic laws, I don't have to follow any laws. Like, I don't have to follow the laws against murder. And people have been murdered by sovereign citizens.
God, I'd totally flip out on them. Just a quick side, because I'm going to have a lot of side notes on this, because I know a lot of people have a lot of questions. If you, like, literally, there are so many things that I will completely flip out. Maybe not immediately, but, like, I am so ready to educate, and I'm so ready to flip out.
You're so ready to educate. Yeah, okay, whatever, man.
That, like, these kinds of things that happen to you guys, like, they just do not happen to me at all. What happens to me is no one wants to talk to me. That's my life. No one ever wants to talk to me.
Well, that may tell you something, buddy.
City of Glendale case that I'm in right now, the attorney, Carl Arias, I have not heard a fucking peep from him. He filed in for a 30-day extension. Docket item number 4, if you go into the case, just as a little side note. Because I haven't done a lot of videos in a long time, so we're going to do some little side quests here. I think you guys enjoy these. I mean, they're pretty fun. So if we go to www and we go down to the current and previous litigation section and we go to the newest case and we go to docket number 4, you can see here that he's asking for, he's going to file on a demur, a motion to strike, or a motion for judgment on the pleadings. And he basically said, I made a good faith attempt to meet and confer with the party who filed the pleading at least 5 days before the date of the responsive pleading was due. No, he didn't. All he did was send me this. All he did was send me an email. Why? Because he doesn't want to talk to me.
He doesn't talk to you. You file motions and you answer motions. That's you don't know how fucking court works, man. See, you have to reply to this asshole. This is part of the process.
So I don't know what buying more time is going to do. If you don't want to talk to me in 30 days, you're not going to want to talk to me either. So I basically filed an opposition, and I said, the defendant's advocate, Mr. Araya, says in his declaration that he, quote, made a good faith attempt to meet and confer, end quote. This is totally false. Complete fabrication. The owner of the plaintiff responded to the email PDF that Mr. Araya sent the next day, which will be attached here as Exhibit A. So go down to Exhibit A. This is the email that I sent him the next day after he sent me that PDF file.
This guy had a conversation with Artie of Artie's Corporate Fiction, and I'm trying to find it.
Hello, thank you for your letter. Yes, Carl or anyone else can call me for the meet and confer, or preferably we can meet in person. The letter doesn't make sense that was attached to the email. I'm not going to get into all the reasons why, but there's all sorts of reasons why that letter is just complete horseshit, and it's just he basically just wrote it to like buy more time. I don't know what he's doing, but I will have more questions that we can go through either over the phone or in person, whatever is preferable. I find it interesting that everyone's now just doing like some sort of sovereign immunity. That's what they did in that letter. Oh, we have sovereign immunity as a public utility. SBA, oh, we have sovereign immunity. It's like, damn, sure is interesting. The sovereign citizen shows up and everybody else says fucking sovereign immunity. Fascinating. I'm available in the afternoon or evenings for calls, and I can even take a call over the weekend if desired. If in person is desired, I will need to schedule that maybe a day or two in advance, right? I'm obviously not hard to get a hold of. Here's the cover letter of the discovery request. I told them, hey, at the end, if you have absolutely any questions, concerns, or anything else, you may contact me by phone. I would prefer any meetings to be in person, if preferable, if possible. I can come to your office, or we can meet somewhere over lunch, etc. So, and then I'll go up and also there was already a process server that delivered the first set of discovery requests. Plaintiff will
Hey, Jordan.
Attach only the cover letter of that packet as well as the proof of service in Exhibit B. Anyways, the whole point is I do want to talk. I'm trying to talk. He's making it seem like I'm not talking or I can't talk or I'm not responding, which is complete horseshit. It's not good faith. It's bad faith, right? So the reason why I'm showing you that is because why not just answer their question? Oh no, officer, I don't have a driver's license. Well, why not? Because I don't qualify to have one. How can I have one? It says that I would have to say under penalty of perjury that I am a resident of, in his case, state of Michigan.
Right. If you live in Michigan, you're a resident of Michigan.
I am not a resident of state of Michigan. I didn't want to break the law and commit perjury by signing the document under penalty of perjury, so I don't have a driver's license. And then from there, it's where do you live? Oh, sir, that's irrelevant.
No, it's not irrelevant.
For the Michigan Vehicle Code or whatever, I don't know what it is, Michigan Vehicle Code, really the whole thing just breaks down into two categories: residents, non-residents, right? So, for example, in my case, it'd be, oh no, officer, I operate under CVC 6700.
That's a vehicle code.
Except as provided in blank, the owner of any vehicle of a type otherwise subject to registration in this code other than a commercial vehicle registered in a foreign jurisdiction may
Right, you don't live in a foreign jurisdiction, dipshit.
Operate the vehicle in this state until gainful employment is accepted in this state or until residency is established in the state.
See, this is for commercial vehicles, dipshit. This isn't... Jesus Christ.
Whichever occurs first, if the vehicle displays valid license plates and has a valid registration issued to the owner, and the owner was a resident of that state at the time of issuance.
You can't just say, I'm not a resident of the state I live in to get around the fucking law, dumb fuck. That's not how shit works. Yeah, he's full of crap.
Some people may say, oh, you don't have any registration.
3 teeth extracted. Shit. Holy, yeah, I bet it does.
You know, I would say to print out your DOT, your private motor carrier DOT.
Dude, the DOT number is the Department of Transportation. That's a commercial organization, dumb fuck.
Registration. That's going to be your registration, and then
and no, unless your DOT number is not your fucking vehicle registration, stupid.
Valid plates are from me, Amnesty Coalition.
No, your plates aren't valid, dumb fuck.
Right? I don't know if I have. So when you do the DOT, the private motor carrier DOT, you can go on and you can print off. When you're in your login for your DOT number, you can print off a sheet. I don't know where it is. I'm not going to try to look for it. I mean, I guess. Hold on. I'll just pause the video. Okay, so here is the sheet that I have printed from my DOT login. We have the name of motor carrier, which is the name of the person, right? We have the principal address, 123 Purple Monkey Lane. City is Pickle-Taria. State is California, because you have to choose.
See, that's all horse shit, man. This is all fucking horse shit. There's no such thing as Pickle-Taria. You live in fucking Glendale, motherfucker.
Choose one off the drop box, and then
there's no address of 123 Purple Monkey Lane, dumb fuck.
And zip code is this zip code.
Operation classification. Private property. Oh. Private passengers, non-business. Look at this bullshit. Look at this fucking bullshit.
And then the mailing address is P.O. Box. So neither of these establish residency, right? This is a
Jesus fucking Christ.
Burner number, because I tell you guys in the video, if you don't use it.
And you're not an interstate non-hazmat carrier, stupid. Jesus fucking Christ, this guy.
The burner number, you're going to get 950 million calls. So this is my burner number. Doesn't go anywhere, really. I don't really use it. Here's the DOT number, and then here is the email address.
Holy Christ. He's here to fucking review this video. Actually, instead of this, let's what we can do is, this is from, see, the original video is pretty short. We might watch that later. Here's his debate with Artie's corporate fiction. Now that we've gotten a good taste of what he fucking thinks passes for law.
Hey guys, so I'm doing a live here. This is the first time I had a live scheduled with Artie. I just sent him the invite.
We probably won't watch the whole thing. Well, we might.
It's annoying. It's really annoying.
Hello, hello.
Hey, there he is. Yo, what's up, dude? Sweet, we're in business.
Finally got this working.
Yeah, sorry about that. I just gave up on the YouTube thing. I know you.
Yeah, he committed fraud. If that's in fact the form he turned in.
You're more familiar with it.
Hey, Cygnus.
I am not.
Hey, Westside.
Right. So, like, whenever I do discussions like this, you don't really rely on YouTube directly to have a connection. You usually rely on an external platform like this, or StreamYard, or Discord. That
is pointing in portrait orientation. That's.
Yeah, that is happening.
His head looks like a real short penis with a little teeny nutsack.
You're seeing that too?
Yeah, you're vertical, and so am I.
I don't know if I can fix that one. I think this is as good as it's going to get, which is pretty good. Can you see the chat on the right hand side? You should be able to see the chat. I don't know if you're in.
Let me see here.
It's kind of shitty on this
Oh,
platform.
I see the chat.
You can only see like 4 comments. I did full screen, so I can see like 4 maximum at a time.
Okay, I do see the chat there.
It tells you what platform they're on, which is kind of cool. It says YouTube, straight up Duder 258 now. You guys
Kind of turn off.
some of the cases you've worked on in the past, and then some that you're working on now. Just like a kind of a bird's eye down overview. It doesn't need to be too brief. I mean, with enough detail to actually know your background and what you do and kind of who you are, if you wouldn't mind.
I mean, sure. I went to law school in 2007, got my license in 2010 for New York and New Jersey. I've been working in New Jersey for like the last 15 years until...
So 15 years working for the state of New Jersey. Now he works for Texas. He moved to Texas. So, yeah, he's got his credentials.
This year, where I was able to get my license in Texas. And then I've since moved to Texas with a new position. A lot of the work that I've done is working in regulatory compliance, kind of boring stuff. But now, with my new position, I'm more often in court itself. And so when it comes to the sovereigns and sovereign citizens, that's not like something that I focus on as part of my professional practice. It's something more of like something as I've had an interest in outside of the profession as like a personal hobby.
Okay. And you used to do regulatory compliance. That would be in what arena, what area of regulatory compliance?
For the longest time, it was with public records access in New Jersey. So that's the primary field.
So it'd be like the state's version of a FOIA request, like that kind of thing?
Yeah, basically.
Okay. And okay, so were you working for the state, like pulling up documents and giving documents to people, or figuring out why they should or shouldn't have said documents that are requested via state version of a FOIA? Is that what it was?
No, I didn't work on that specifically. But I mean, that was not what's I didn't work on actual like records requests per se. It was more about the law in general and how it's being applied at the state level.
Within the confines of the arena of information and information releasing?
Correct.
Trump really is running.
Okay, and then now you are in the courts more often. Now, regulatory, it doesn't sound like you were ever really in the court. That's just paper, right, basically?
Right.
Okay. And then now, what are you doing now? Now, this new thing in Texas where you're in the courts, what field or area are you working in now?
I mean, I'd rather not go into further detail about my profession, if you don't mind.
Okay. Can you give us at least a general idea as to what the field is? Like, even if it's just like one word, like immigration or whatever, or like criminal or something.
I mean, I'd rather like keep it as it is right now.
Okay. No problem. I don't want to get uncomfortable.
The nature of the internet can be weird sometimes.
Okay. Yeah, no problem. No problem. So, can you say at least civil or criminal? Can you at least go that far? So we.
No, I'd rather keep it vague.
Okay.
If you don't mind.
No problem. So, okay, have you ever worked privately or for any sort of private practice, or have you ever had your own practice in any way, or taken on private clients?
I've worked in private practice before, but then I kind of have to ask you, why are you asking me these questions? I thought we were having a discussion about U.S. citizen versus state citizen. I don't understand why you're...
It's just to understand you. I mean, I don't, the whole point of this whole thing is that we have somebody who's a licensed attorney and somebody who's not, somebody who's just this fucking goofball weirdo on the internet. So establishing...
You're not like a goofball on the internet. You're trying to advertise legal knowledge for people to actually use in practice, are you not?
I don't use the word practice, but yeah, essentially. The word practice is a legal term.
Right, so you're trying to convey your knowledge to other people who are ostensibly paying for your services, right?
Well, they're all donations. They're legally classified.
Oh, donations, and they get a license plate and a fucking passport card.
As donations.
Sure.
So there's no actual contract.
And I bet your videos are for educational use only, huh?
In terms of how you'd think a contract, but beyond that, yes.
Right. So I feel like you don't.
There's no legal obligation inside of the trustee beneficiary relationships that I create. There's no contractual relationship. It's more of a fiduciary relationship, I suppose, than a contractual relationship because it is a donation.
Right, but do you not feel obligated to act on their behalf if they give you a donation for a certain service?
Yes.
Okay. So, like I said, you say you're like just a goofball on the internet, but in reality,
You know, I could say that I'm donating money to a prostitute, but it's still prostitution. Still paid for services.
you are, in fact, offering services to people. Whether or not it's in the form of donations that you receive, you are offering services to people as part of your conveying your legal knowledge.
Yeah, that's correct. I guess the reason why I'm asking all the questions is just to establish kind of like your background, who you are, what you are, because people are going to want to know that. Like, who is this guy? He's debating Brendan Williams. Like, what's his background? What does he do? And it sounds like, a lot of your history is mainly in governmental type area. So that's all. Just wanted to establish that. There's not much more to it. I mean, that's all.
Okay.
So I guess from here, yeah, we can just go ahead and get started. I just wanted to say, I've seen a bunch of your videos. I did see the video that you did in prep for this show.
Mm-hmm.
And the reason why I decided to kind of debate you, because I get offers for a lot of debates, is because you've been doing this kind of stuff and talking about this stuff for quite some time. How long have you had your channel for?
This particular channel since 2019.
Yeah, so it's been 6 years you've been doing this. Okay, perfect. So yeah, so I guess that's enough to just kind of roll into it. I want to go ahead and today we're going to be talking about the differences between state and federal U.S. citizenship, what that means, and does it even exist? I guess is really where we're going to go with this, because I already saw you were live where you were making the notes for your audience. So I'll just do a screen share on my end, and then what I'd like to do is just kind of go section by section. Originally, I was gonna use the treatise on the word person, which we can't use, but I have all those same quotes over here. So I'm rewriting an Army training manual from 1928. It's called TM 2025. It was released by the Army, and it was used in the Army between the years of 1928 and 1932. And I'm rewriting it and modernizing it, essentially, which I'm not going to get into what that means, but all the details is what that means at the top of the screen. It has all the same information and all the same quotes and everything, but there's also a ton of intermediary information that I've added to it that I would rather use.
Why are you rewriting an Army training manual? What the fuck, dude?
But most of it is the same as what you read in the treatise.
Right. So I think a fundamental a foundation of this entire discussion is going to be on identifying not just what a state citizen and a U.S. citizen is, but also the nature of what is an individual, what is a person, what is people. Because I feel like that serves as a foundation for all of your arguments coming after that. So I mean, the first question I would have is, while I understand that your treatise cites multiple different federal statutes when it comes to defining person, are you using the immigration definition as like the fundamental one?
For the federal citizen side of the equation, yes, because if you go to, for example, 8 U.S.C. 1101, most people think that this has to do with citizenship, which it doesn't. It has to do with aliens and nationality. The definition of Title 8 is aliens and nationality. You don't even see citizenship really in Title 8.
Title 8 deals with immigration specifically.
Well, yeah, but no, because it deals with U.S. citizens and non-citizen nationals under subsection A22. It has both.
Well, it defines who U.S. citizens and non-citizen nationals, correct? And then yes, it'll subsection of the of Title 8 talks about the naturalization process. So of course they're going to define what a U.S. citizen is.
Yeah, it's part of that, but it had. I mean, where else would it be? I guess would be my question to you. Like, where else would it be?
Well, I feel like you pointed out in your treatise there are multiple different parts of the U.S. code that defines person.
Yes, and the reason why I'm using this definition of the word person is because, as far as I'm concerned, it's the best and closest thing, at least, to anything that would be involved in citizenship, because you have to have nationality first before you can have citizenship, which is really obvious looking at subsection A22. The term national of the United States means A, a citizen of the United States, or B, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. So this proves that a person can have nationality without citizenship. But the thing is, a person can't have citizenship.
To the people of Guam, not Guam, but the American Samoa.
No, I understand that. But I'm just saying, it is what it is. You can have it is possible to have nationality without having citizenship, but you can't have
but that
citizenship.
Is a very, very tiny portion of the American population.
I don't disagree with you, but I'm just saying it is what it is. I'm not saying anything more than that. It is what it is. It is. You can have nationality without citizenship, but you can't have citizenship without nationality. So nationality is the first tier, and then the second tier after nationality has been established is citizenship. That's all I'm saying. So you're saying, why are you using this definition? I'm saying, because I don't know of anything that would be a better spot to use this information from. If there is a better spot to use this information from, then by all means, tell us.
Well, I guess my contention is that if I am to understand your treatise, is that the classification of a state citizen is one that is of a more preferable classification than a U.S. citizen. Do I have that correct?
It depends. it depends on how you look at it. It's preferable if you meet the requirements to be one. I think so. I suppose there is some subjectivity to it, but I think objectively, I would say yes.
Okay, so then if that's the case, then why not use the state's definition of person instead of the feds? It's because if the federal constitution and anything deriving from that is reserved for U.S. citizens, why bother relying on the fed's definition of person instead of the state?
Well, no, a state citizen still has access to all the federal protections. There was a federal government and there was federal aspects in the federal constitution prior to the advent of the U.S. citizen category.
But there was also state constitution, correct?
Yes, of course.
So then what would be the point of the federal constitution if the state constitutions are supposed to protect those rights for the state citizens?
Well, that's the whole point of the dual nature of America. That's been the argument in the court since literally John Marshall's time period. I mean, that's always been the argument. There's two entirely different systems. The thing that makes it so complex, which I wanted to get into with you, is the fact that there's two different governments. There's one that runs underneath all of the states as a union, and then there's an entirely separate government under the District of Columbia and all of its possessions, which would be the U.S. territories and insular possessions. That secondary class, which essentially the way they describe it a lot in the Supreme Court is, under Congress, that second class didn't have its own citizenship class until the U.S. citizen category was created. So it didn't have its own citizens. So in today's world, we have two different worlds, two different governments, both with their own citizens. But prior to the advent of the U.S. citizen category,
no, man, no.
Congress did not have a citizenship class.
Well, I don't know if I can agree with that, because if you go to the Naturalization Act of 1790, I mean, the first paragraph talks about how somebody is to become a citizen, but that first paragraph does not say anything about this is the way in which you're eligible to be a state citizen of whatever state you're residing. It's to be a citizen of the United States.
Yeah, that comes from the Constitution. I forget exactly where that is. Let me see if I can.
So then, a U.S. citizen has absolutely been in existence since the nation's founding.
Yeah, but the definition was really different, which is actually covered by Mr. Miller in the slaughterhouse cases. But give me 1 second. Where in the Constitution does it talk about how citizenship is of one of the several states? The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. This is a lot of what they were talking about in when they were which I want to go over with you today. This is a lot of what the guys a lot of what Senate and the House of Representatives were talking about when they were presenting the 14th Amendment to be approved. They were talking a lot about this and stuff like that, which I actually just recently, yesterday, just added all that information, and I found all the original quotes from the various people who were talking about all this, and I put it into I didn't put it in the treatise, I put it in this one, because this is actually going to get made into a book. So let's just start at the beginning. I kind of wanted to just start at the beginning and walk through an entire timeline with you, all the way to the the first thing I wanted to cover was the preamble of the Constitution, right? In the preamble, it says "we the people," and you can agree with that, right? We the people, right? And the word "people" is capitalized. There's a bunch of different random capital words, like the word "union" in most Supreme Court cases is capitalized throughout all the 1800s. So that's actually a capitalized word. The word "people" is capitalized. Whatever, right? And then we have the slave trade clause on the U.S. Constitution.
And it has persons. I understand your.
Well, I understand
what you're saying here.
This is not.
You're trying to delineate a distinction between people and persons.
Hold on now. Slow down. What do you mean? It's not me. It's not me doing this. I don't want you to say it's me doing this. Who's doing this?
You.
No.
This is your interpretation.
No, it's not. Whose interpretation is it? It's not mine.
Yours.
No, it's not. It's not mine. Whose is it? I'm asking you. Whose is it?
It's not yours. I'm saying it's yours. You can say I'm wrong, but I'm saying it's yours. You can tell me who it is.
It's the 5th Chief Justice of the United States, Roger B. Taney.
Are you sure about that?
100%, which we're going to cover all the quotes.
Wait, Taney was the author of Dred Scott, correct?
That's correct.
And you're aware that that's been overturned, correct? By
the slaughterhouse cases, yes.
Right, and so you also understand that, therefore, the distinctions that you can delineate from Dred Scott doesn't really apply anymore?
No, because all the stuff that's in Dred Scott is all talked about and it is all related. Everything from Dred Scott.
It was discussed, and then the author of Dred Scott, Miller, effectively said that Dred Scott doesn't apply anymore by virtue of the 14th Amendment.
Well, it's by virtue of slaughterhouse cases, and the 14th Amendment both, but it wasn't really clear until the slaughterhouse cases. But yes.
Right. So then, as a result of the slaughterhouse cases, it effectively said that persons are all one.
No, that's not what it says.
Yes, it does.
No, we're going to cover that in great detail. We're going to cover all of the Civil Rights Act of 1866. We're going to cover all of the quotes that people were saying when they were presenting the 14th Amendment to Congress. We're going to go over all of it. I've got everything here. I've got such an extensive library that we're going to go through, and I want to go through it, but I want to go through it on a timeline. I want to go through it by date because I want to build the whole story by date. I don't want to jump around. You know what I mean?
But I think the problem is that you want me to walk along your framework, but I have a disagreement on your entire framework here. I understand you want to build this up to this conclusion that people means white people, persons means freed African slaves. I mean,
persons means non-white. It's more than that. It's non-whites. Mr. Miller is clear about that in slaughterhouse cases. It includes all non-whites.
And white people.
No, it does not include white people. You can see that even on the first line of the Civil Rights Act of 1866. You can see it's very, very clear. Be it enacted that all persons in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens
of every race and color. How does that not include white people?
You'll see. Without regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, give evidence, inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens.
So then white people are already U.S. citizens.
Yeah, but the definition of what that meant prior to this point is it meant a citizen of a state. And you can see that even in Bradwell v. State, which happened the day after Slaughterhouse. He's still talking about the state citizen category.
No, what the 14th Amendment did is put the status of non-whites to the same level as white people.
That's correct.
So, yes, so then white people are
but
US
in
citizens
itself,
along with
the 14th,
non-whites.
why would the white people need the 14th? They already had everything. Why do they need the 14th?
I understand that. That's the point of the 14th, was to bring them on the same level as white people as U.S. citizens.
We're not in disagreement about that. It's just
so then white people are U.S. citizens.
No, white people never needed the 14th.
You just told me you agreed with me.
The 14th Amendment the intention was to bring non-whites to the same level as the whites. That is correct. That's what you just said. I agree with that entirely. In fact,
as U.S. citizens, and if the 14th Amendment made those non-whites U.S. citizens, then logically that means that white people were already U.S. citizens, and the non-whites were brought to the same level as white people.
No, they were state citizens. It even says in the Constitution, state citizens.
Wait, so then
and I can prove this.
If I agree with you, then non-whites are state citizens.
Now hold on. So the very next day, and I can click on. I have a link here. We can go straight to the original.
I really want to press you on this. If you all agree with me that the purpose of the 14th Amendment was to bring non-whites on to the same plane of equal standing in terms of rights and protections as white people,
yes.
How then do you then argue that there are still two distinct categories or classifications of non-white U.S. citizens and white state citizens?
Because the original intention, if you look at, let me go back to the treatise. If we go down to, this is way later, but we can jump around a little bit, I guess. If we go down to shit. Hold on one second. I just added this yesterday, so it may take me just a moment to find it. I found all of the original speeches when they were trying to pitch this thing. Here we go. So these are all the original quotes from the guys that were pitching the 14th Amendment, right? And you can see here, there was a guy named Thaddeus Stevens. Mm-hmm. And on June 13th, he said, your civil rights bill, talking about the Civil Rights Act of 1866, some answer that this secures the same things. That is partly true, but a law is repealable by a majority.
Right.
And all I need hardly say that the first time that the South with their copperhead allies obtain the command of Congress, it will be repealed. The veto of the president and their votes on the bill are conclusive evidence of that. Stevens emphasized the amendment's permanence. This amendment, once adopted, cannot be annulled without 2/3 of Congress. That they will hardly get. Right. And then this is to your point. This is exactly what they're saying. Whatever law punishes a white man for a crime shall punish the black man precisely in the same way and to the same degree. Whatever law protects the white man shall afford equal protection to the black man. Whatever means of redress is afforded to one shall be afforded to all. Whatever law allows the white man to testify in court shall allow the man of color to do the same. Now, different degrees of punishment are inflicted, not on account of the magnitude of the crime, but according to the color of their skin. Now, color disqualifies a man from testifying in court or being tried in the same way as white men. Now, where did this come from? It came from Dred Scott versus Sanford. So keep in mind, at this time in 1866, we hadn't had the slaughterhouse cases yet. So this is still the Dred Scott era when they're talking like this, right?
Well, yes, this is Dred Scott era, post-Civil War, and in the midst of creating the 14th Amendment. This
is in the middle of the Reconstruction time period. We're about a year and a half into the Reconstruction time period.
Nothing that what Thaddeus says, I disagree with. I
me neither.
Agree with everything that he says.
Me neither. And I
don't know how this furthers your argument here.
It's not furthering my argument. I'm just showing you. Basically, you're saying these things, and I'm agreeing with you, and I'm showing you the original material as to where the agreement comes from, right? So what they were trying to do was, they were trying to get the Civil Rights Act of 1866 because the South was going fucking ballistic, the black codes and everything else. They were trying to prevent the southern states or people with southern mentality to be able to easily get rid of the Civil Rights Act of 1866. The way in which they were trying to make it more permanent was by making it into an amendment. That amendment became the 14th Amendment.
Right.
Now here's to go all the way back to your original question. Is the answer is right here. So John Bingham, February 28th, 1886 says, and this is involving the 14th Amendment, the proposition pending before the House is simply a proposition to arm the Congress of the United States by the consent of the people of the United States with the power to enforce the Bill of Rights as it stands in the Constitution today. It hath that extent no more. So what happened was the intent was good. The intent was to try to bring non-whites up to the same level as the whites. Okay. But because they were saying shit like this, This is why we have the incorporation doctrine.
No, the problem with the incorporation doctrine is that it is a result of the slaughterhouse cases effectively neutering the 14th Amendment and its applicability to the states.
But U.S. citizens are not. It's a citizenship class. It's a federal citizenship class.
Again,
it would fall under the 14th
citizen
Amendment.
has always existed since
That's correct.
The initial founding of the country.
Now stop right there.
Yes.
Because people always say that the slaughterhouse cases and the 14th Amendment created one citizenship class. I can prove that's false. I can actually prove it in Bradwell v. State.
I'm not necessarily saying that it's that U.S. citizen and state citizen are one and the same, but the court explicitly said that U.S. citizen is created through the naturalization process. Being a state citizen, the only thing that you need to do to be a state citizen is simply to reside in the state that you're in. Like the moment I moved from New Jersey to Texas, I became a state citizen of Texas.
Yeah, but you don't have state citizenship and U.S. citizenship, as Mr. Miller goes into extensively in the slaughterhouse cases, are completely separated. You can have one without the other.
Right. Yes. If you live in an unincorporated territory, such as D.C. or in American Samoa.
No, that doesn't.
Where they're in American Samoa, they're nationals. They don't have a citizenship rights. The same reason why in Puerto Rico is not a state, but it has U.S. citizenship by virtue of Congress.
Yeah, it's a U.S. territory.
Correct.
I'm not disagreeing with you there.
I'm not disagreeing.
But a Puerto Rican wouldn't have a state citizenship class that's the equivalent to what the white people had prior to 1873 or 18. I say slaughterhouse, so I'm just going to say 1873. If you want to say 14th Amendment, 1868, fine. It's kind of the same thing. I'm going to say slaughterhouse. Prior to 1873, what Puerto Ricans have, they don't have access to what we had prior to 1873. They never have because it's a U.S. territory.
Well, Puerto Rico wasn't even a territory until like 20 years later. But that's beside the point. The point I'm making is that I understand that there is a distinction between a U.S. citizen and a state citizen. I understand that you can be a U.S. citizen and not a citizen of a state. I mean,
hey, Stanley.
How many Americans living abroad have retained their U.S. citizenship despite not living in a state at all? So of course that exists. I think that where our disagreement is going to be is this idea that being a U.S. citizen confers, I guess, substantially fewer rights than a state citizen. Because according to you, a U.S. citizen is required to get a driver's license, etc., whereas a state citizen doesn't have to. But
look at the incorporation doctrine. What does the incorporation doctrine say?
I will also we can go into incorporation. I will also point out to this idea that one of the fundamental aspects of your argument is that the 14th Amendment is inapplicable to white state citizens. Correct?
That's absolutely correct.
So then,
I can prove that, by the way.
Why do we have white people who constantly file suit in federal court under the 14th Amendment, alleging 14th Amendment violation?
Because as far as I can tell, it's just under Rule of Evidence 301. It's just presumption.
But if it doesn't apply to white people, why are they bothering?
Because it's a presumption, and the opposing party doesn't rebut the presumption, so the presumption stands as fact in law. It's a what do you call it when both parties agree with fact? Stipulated fact.
I mean, okay, that seems kind of weak, but I would also point out to page 72 of the slaughterhouse cases. I mean, maybe you saw this when you saw my live stream, where the majority opinion explicitly say, quote, "We do not say that no one else but the Negro can share in this protection. Both the language and spirit of the articles are to have their fair and just weight in any question of construction. Undoubtedly, while Negro slavery alone was in the mind of Congress, which proposed the 13th article, it forbids any other kind of slavery now or hereafter." And it goes on to say about Mexican peonage, Chinese labor system.
Chinese labor system. Yes, I understand.
Yes. So this explicitly
he's saying
says
non-whites.
that
He's saying all non-whites.
He's saying everybody.
No, I can prove
whites
this.
Included.
I can prove this. Hold on one second. So again, Bradwell v. State. This is it. So slaughterhouse was April 14th, 1873. The next day, April 15th, 1873, we have a case, a glorious case, which explains all of this and proves everything in beautiful color, high definition color. So the record in this case is not perfect, but it may be fairly taken that the plaintiff asserted her right to a license. She's trying to get a license to practice law, and she's female, and she's white. Okay. Among others, that she was a citizen of the United States, and having been a citizen of Vermont at one time, she was, in the state of Illinois, entitled to any right granted to citizens of the latter state. So it's a little bit confusing. So you have an original, what I would call domicile state. You have a residency state, which is the secondary one, and then you also have her saying that she's a citizen of the United States. So you have three different classifications here, right? And he clears this up beautifully, right? This is Mr. Miller, by the way. As regards to the provision of the Constitution that citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states, the plaintiff in her affidavit has stated very clearly a case to which it is inapplicable. And this is the bombshell right here. The protection designed by that clause, as has been repeatedly held, has no application to a citizen of the state whose laws are complained of. If the plaintiff was a citizen of the state of Illinois, that provision of the Constitution gave her no protection against its courts or its legislation.
I know. No, again, this comes to a fundamental misunderstanding of what he was saying in the slaughterhouse cases. He is saying that the 14th Amendment only protected all people, of abuses by the federal government, and that, in other words, if the federal government violates my right to my free speech rights through some act of Congress, then I can sue under the 14th Amendment, challenging that violation. that he said that, however, he said that the 14th Amendment does not apply to the states. So the states and the state constitutions apply, and a person who sues in federal court under the 14th Amendment that a state law violated their First Amendment rights cannot is not going to go anywhere. That thus going into the incorporation doctrine of basically the Supreme Court walking back the slaughterhouse cases slowly.
No.
Yes. And again,
no, the 14th Amendment was to give the non-whites protection from state abuses, specifically the southern states.
But how can you say that when the slaughterhouse cases effectively gave a green light to Jim Crow?
No, Jim Crow was already there. The 14th Amendment was actually, during that whole Jim Crow back and forth punch, one side punches, the other side punches, that was just kind of part of that whole 1856, 1866 time period.
Okay, if you're arguing that the 14th Amendment was to protect non-whites against state abuses, why did Jim Crow happen for the next 30 years after the Civil War and didn't really die off until like 1965?
Because the southern states were pissed. They didn't want any of this. They were fighting this from the beginning. There was a military occupation. The federal government did a military occupation of 10 of the southern states.
Yes, I understand that. What I'm asking is how, if the slaughterhouse cases provided non-whites with protections against state abuses, why didn't any non-white who was living in Alabama, for example, sue in federal court against these sundown laws or curfews or laws against miscegenation? Why
a lot of that was
1870, 1880.
A lot of that was the slaughterhouse cases. The slaughterhouse cases was a whole shitload of cases that all got wrapped up into one giant monster case.
But those laws kept on going. Are you just saying that the states just basically told the feds to fuck off after the slaughterhouse cases?
Well, yeah, of course. So the states have always been sovereign. The 50 states are totally sovereign. I mean, you can see that even in the in Title 48.
I mean, you also understand that the federal court system can overturn a state law, right?
It can't. They do it, but they're not supposed to. You can see that. I actually just wrote a writ of certiorari on this exact subject, and I'm actually submitting it this week to the Supreme Court. So if we go to, I'll show you the area that they use on me that I can actually show you to prove this.
So I want to put it on the record. You were arguing that today the state of Alabama can reenact sundown laws, and the feds are not supposed to be able to overturn that.
The feds can't overturn it. But it basically becomes essentially almost like a brand new civil war because the feds will use the 14th Amendment to say that the states don't have the right to do it within the confines of their own state. And that's why there's been so many people that have thought in the past that the slaughterhouse cases in the 14th Amendment are unconstitutional. And I'll show this to you if we just give me a second here. So I sued the SBA in state court because it was a UCC claim, which is not federal law necessarily, depending on who you ask. And the
UCC is not...
Yeah, I don't know how I feel about that. I understand that that's a fact, but then, like, how do they handle negotiable instruments in federal court? They handle it using the UCC. And they'll go like, oh, the UCC is different state to state. No, it's not. Go read.
Yes, it is.
It's one word occasionally. One word occasionally may shift a little bit.
Some states have omitted whole chapters of the model UCC code.
I understand. That's a vast minority. Vast minority. In fact,
it's not the same across the states.
In fact, the UCC, not only is it pretty much almost the same throughout all the 50 states of America, it's pretty much the same in almost every country. It's literally almost the same everywhere in the whole planet. So the idea that it's not and all this kind of bullshit.
Some level of similarity, but it's not as if
it's like 90%. It's like 90% at the lowest level everywhere on the whole planet.
Okay, I can
assure you.
Disagree with that, but you can
disagree with it all you want. Now let's get back into 28 U.S.C. 1442. So they removed the case. The SBA removed the case from state court to federal court, and I said you can't do that. And they said, what do you mean? And I said, well, under 28 U.S.C. 1442, subsection D6, it has the definition of a state court. The state court includes the Superior Court of the District of Columbia, a court of the United States territory or insular possession, and a tribal court.
Right.
And the DOJ attorney said, well, the word includes means it includes the other 50 states of the Union. I said, where did it say that?
Well, yes.
Where did it say that?
How do you not? Are you serious?
Where did it say that?
The term state includes the District of Columbia, United States territories, and its insular possession in any country. The term state court includes the Superior Court of the District of Columbia, a court of the United States territories. I don't know how you can parse that unless you literally don't think that the United States, as defined there, means the 50 states.
I can prove it.
Okay.
Here we go. Kaha versus U.S.
Try.
So in Kaha versus U.S., he's talking about this split between federal jurisdiction and state jurisdiction. This statute is one of universal application within the territorial limits of the United States and is not limited to those portions which are within the exclusive jurisdiction of the national government, such as the District of Columbia.
So that means
generally
all
speaking,
states.
Nope. Generally speaking, within any state of this union, the preservation of the peace and the protection of person and property are the functions of the state government and are in no part of the primary duty, at least of the nation. The laws of Congress in respect to those matters do not extend into the... Let me finish. The laws of Congress in respect to those matters do not extend into the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. So,
which statute is this talking about?
I don't remember. Is California...
You don't think that matters?
Well, no, not for this. I've seen enough other things. Just hold on one second. Is California within the exclusive territorial jurisdiction? We'll see if they change
of course
this,
not.
Of the federal government.
The answer is obvious that it's not. The state of California has its own state government. Nevada, like 90% of Nevada, does have concurrent jurisdiction with the federal government. I don't know why you think this is a point towards you, because it's not as if the federal governments have no jurisdiction in, or federal law has no jurisdiction in the state of California. I don't know why you think that.
Well, it would only have jurisdiction under the Commerce Clause.
No.
That's the whole point of the Commerce Clause.
No.
Yes. For it.
Say what? Say what? You mean if I commit murder, which is a federal offense, I can't be investigated and prosecuted by the feds?
Nations, interstate commerce, and commerce with Indian
laws
tribes.
passed by Congress apply to everybody, not just DC. Yes, of course it does.
Yeah, they do, dumb fuck. Yes, they do.
Exactly why Title VIII doesn't have a state citizen in it, because it doesn't have anything to do with it.
Okay.
You don't see state citizen anywhere in Title VIII.
Well, of course. Well, yes, because there's no naturalization process to specifically be a state citizen.
Because
it's
it's a
only
foreign
a US
jurisdiction.
Citizen. No, it's just to be a U.S. citizen, and then a U.S. citizen, depending on where they live, can also be a state citizen.
No.
Yes.
They're two totally separate things. Why?
No, that's how the world works right now. I don't know if you understand that.
No.
But
so let's go back to the slaughterhouse cases.
I want to put it on the record that the only person who's making this interpretation is you. You're going against everybody, the entire body of work in legal interpretation.
No, there are
judges,
a lot of
across
people.
Courts, across other attorneys.
There are a lot of people. Ever since the slaughterhouse cases, there has been a nonstop amount of very, very well-known judicial people, and even Clarence Thomas has talked about it extensively, that the slaughterhouse cases is just not right, and it needs to get fixed. There's been a million people that have said that. It's not just me.
Well, yeah, I think most people say the slaughterhouse cases was bullshit law that neutered the 14th Amendment, allowing Jim Crow to fester for the next 100 years until the incorporation doctrine came to be.
Yeah, but let me ask you a question. If your theory is correct, why would white people give Congress the ability to tell them which Bill of Rights applies and which one doesn't? Makes no sense
okay,
at all.
Let me understand that. You're saying, why would white people what?
Why would white people want or allow, and how would it even be constitutional, for white people to give Congress the ability to incorporate or not incorporate the first 10 Bill of Rights at will?
Because the point of incorporation was because the 14th, as a result of the slaughterhouse cases, the 14th Amendment did not apply to alleged grievances, alleged violations of the Bill of Rights under state law. Under
Hey, George.
federal law, somebody could sue the federal government under the 14th Amendment, challenging a violation of their rights.
That makes no sense.
It doesn't. But as a result of the slaughterhouse cases, it did not apply to the states until incorporation came to be.
No, that's ridiculous. We're going to read. Let's read the slaughterhouse cases. This is
basic
ridiculous.
Constitutional law.
No, it's basic insanity. So let's read this. Let's read this.
Sure.
So the first section of the 14th article, to which our attention is more specially invited, opens with the definition of citizenship. Not only citizenship of the United States, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by act of Congress. It has been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It has been said by eminent judges that no man was a citizen of the United States, except as he was a citizen of one of the states composing the Union. Now, I found
it has
tons
been
of these.
said. It has been said.
I understand. I understand.
So he's saying that that's not like law. That's not hardcore. The actual answer, correct?
Well, it had been. There's tons of Supreme Court cases talking about this.
He said no such definition was previously found in Congress, nor had any attempt to be made to define it by Congress. In other words, it's been an open question.
Well, no, because look at this.
Defines a U.S. citizen.
Those, therefore, who had been born and resided always in the District of Columbia or in the territories, though within the United States, were not citizens. The District of Columbia, U.S. territories, and insert possessions are not states. The word state shifts. When you're talking about state statutes, the word state means one of the 50 sovereign states. When you're in federal statutes, the word state means U.S. territories, insert possessions, the District of Columbia,
and U.S. states.
No, it does not. It never includes that. No, it doesn't.
Yes, it does.
Nope, it does not.
Yes, it does. I don't know.
California is not within the.
So this dumb fuck is arguing, who's never been to law school, is arguing with a 15-year plus lawyer.
Exclusive territorial jurisdiction of the United States.
But there's concurrent jurisdiction. You know that's the thing, right?
Yes, but it's not exclusive territorial jurisdiction. I'm telling you the exact legal term.
Exists.
It's not
jurisdiction.
I'm saying it's not exclusive jurisdictional jurisdiction.
No, as well as state law, California can
not unless you have the Commerce Clause.
Not
unless you have the Commerce Clause. Nope.
I know you think that.
Nope.
But Article 1, Section 8 has more than just the Commerce Clause.
The Commerce Clause was the primary door. That it was
yes,
the only
I know. I read
door.
Lochner before. I understand what you're saying. That the Commerce Clause has open the door to the Feds, Congress being allowed to pass a lot of legislation.
Yes, because they've made everything.
Would not have been considered to apply.
Yes, because they've made everything commercial, and they've made everyone.
No, they didn't make everything commercial.
Yes, they did.
No,
everything is commercial.
I always love that you guys cite that CFR provision. Is murder within that?
Yes.
No, it's not. Murder, rape, and assault are not in that cadre of
from the CFR 27.2, whatever the fuck.
Yes, you guys always cite that all the time.
There's a few things. Okay, fine. There's a few things that aren't commercial. Everything else is.
No, it's not. If you actually pay attention to what they're describing specific violations that are obviously involve a transaction.
Which is commercial.
So like prostitution involves a transaction, wire fraud, transactions.
That's commercial.
Drug trafficking, that's commercial because it's a transactional. Murder is not a transaction. Assault is not a transaction. Robbery.
There's still a bond created associated with that, which still makes it to some degree.
What do you mean a bond is created?
All right, we're not going to get into that. I don't have anything to show.
Yeah, I know you don't want to get into that because I've heard that one before too, and it's kind of ridiculous, especially when I worked as a law clerk, for a judge for a year, and you guys thinking that some sort of commercial transactions created with each case is kind of funny to me because I worked in behind the scenes and none of that actually happens. We just file your case, we put it in there and put it in archives, and we wait for your next docket hearing. Okay. I don't have a Wall Street number that I use your bond to play around in the stock market, but if I'm going to go back into I want to go back to one section here under the slaughterhouse cases. Okay. Yes, I want to go back to a particular portion of the slaughterhouse cases because this goes into your argument that this idea that the slaughterhouse cases created this distinct category of U.S. citizen that I guess white people aren't privy to or aren't allowed to be.
You can see that in the California Supreme Court case, Ellen R. Van Valkenburg.
I know the Valkenburg case. Did you actually read that case?
Yes.
So you understand that involved a white female who wanted to vote, correct?
Yes.
But then you understand that the court explicitly said that she's a citizen of both the U.S. and of the state of California.
Yes, you did mention that in your stream. The reason why they said that is because she said it first. I'm dead serious.
He said undoubtedly she is.
Undoubtedly, yeah, but she said it first.
And so the court's agreeing with her.
Them. That's correct.
So then what's the argument here?
Well, that would be under 301. I could say I'm a purple people eater, and the court could be like,
Vet Pro didn't exist until like the 40s, correct?
It doesn't. If
federal
she
rules didn't
says
exist until like the 40s.
If she said that she's these things, even in U.S. versus Cruikshank, they said that a person may be both a state citizen and a U.S. citizen. May implies.
I know that may. Well, yes, again, we already had this discussion. A Puerto Rican isn't a state citizen, but they're a U.S. citizen. Nobody's disputing
That's correct.
that.
I agree with you.
But I'm telling you that a U.S. citizen, a white person, is a U.S. citizen and a state citizen.
They may
Period.
be.
End of.
Now, keep in mind, U.S. versus Cruikshank was 1876. Legal fictions were not added in under the 14th Amendment as persons until 1886. So Cruikshank was at a time period when corporations had not been included under the 14th Amendment definition.
Why did he pronounce it persons? Why did he pronounce it like that?
Of persons yet.
Okay.
So that's very important.
How? Why?
Because in Cruikshank they hadn't seen the confusion that was going to happen after Southern Pacific Railroad, the 1886 case where they added in legal fictions as persons under the 14th Amendment. And Mr. Miller is really clear about that too, as well in Slaughterhouse. But let's read a few more of these.
I'm looking at this from Miller as well.
So then all the Negro race, who had recently been made free men, were still not only not citizens, but were incapable of becoming so by anything short of an amendment to the Constitution. To remove this difficulty primarily, and to establish a clear and comprehensive definition of citizenship, which should declare what should constitute citizenship of the United States and also citizenship of a state, the first clause of the first section, obviously of the 14th Amendment, was framed.
Yeah, also, you understand that the first section also says that the all persons born and naturalized in the United States are citizens of the United States and of the state they reside?
Yes, but the word reside is obviously where I'm going to have a problem with that, but yes.
Of course you are. So then, therefore,
Yeah, he has a problem with it. Like, that fucking matters.
A freed African slave can be a U.S. citizen and a state citizen.
Well, they reside in the state. I think it's never really been... It's never really even been talked about.
Good
I think
Lord.
Functionally it doesn't work the same because they're resident.
Yeah, they live there. If they live there for a certain period, yes.
No. I can prove that one too. If we go
I'm sure you can, but you haven't really proven anything so far.
Well, you say that, but we'll see what the audience thinks. So,
of course.
If we
No, you haven't proven anything so far, and your audience will agree with everything you say because your audience is as fucking dumb as you are.
Go to Barnes is the word resident, and I found this. This is pretty interesting. Look at this. This is 36 USC 70501. The foundation of the Federal Bar Association is a federally chartered corporation. The corporation is declared to be incorporated and domiciled in the District of Columbia.
And
domicile and residence, there's a rich history of definitional
there's a distinction. I understand there's a distinction between domicile and residence. What does this have to do with the 14th Amendment saying that
because they reside in a state.
So
they
reside
reside
they can be
in
US
a
citizens.
state.
So they can be U.S. citizens, or
yes.
They can be state citizens.
Well, it's a whole that they reside in the state, so it's still it's a lower class of state citizen. It's not the same class.
So now there's a secondary class of U.S. citizen. First you say that there's federal U.S. citizen and state citizen. Now you're saying that there is a subclass of state citizen.
Well, I don't. That has never been. No one's ever brought that up in any case. There's no way for me to even talk about that. There's no precedent. There's no case
this
law.
Is something that you kind of made up on your own.
No, the word reside is the word reside. It's not the word domicile. Period. End of story. People like to make it.
I'm not
people,
saying that I'm not saying that they're completely similar in every aspect. I'm not saying that at all. I'm saying that the language of the 14th Amendment is clear.
It's not clear.
A freed African slave could be a citizen of California and the United States. Yes.
A freed African, yeah, but it includes all non-whites. It's not just. It was originally created for.
And also, white people are also U.S. citizens.
Why would white people need this? Why would white people need it? We never needed it.
It's not a question of whether or not they need it. It's the fact that they were already U.S. citizens. Freed African slaves are also now U.S. citizens and state citizens.
No. Let's get into some more. No, let's get into some more quotes. He talks about this in Slaughterhouse.
I'm looking at page 73 of the Slaughterhouse cases, and you even have it right there. You're highlighting it right there. I don't know how you think that you could read this and think that it actually supports your argument. The main purpose of to establish the citizenship of the Negro could be admit of no doubt. The phrase subject to jurisdiction, blah 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 blah. But it says it overturns Dred Scott by making all persons emphasis added. By emphasis in the original, I should say, born in the United States and subject to jurisdiction, citizens of the U.S. It's saying all persons. It's clear the intent of the author is saying that all persons is meant to mean everybody, not just non-whites.
No, I can show you. Check this out. 42. We'll go to the Civil Rights Act. Let's go to the Civil Rights Act. Look at this. Equal rights under the law. We see it now in 42 U.S.C. 1981. All persons within the jurisdiction of the United States shall have the same right, and it's the same we saw before, as is enjoyed by white citizens.
Yes, white U.S. citizens.
Well, that meant something. That just meant a citizen of a state prior to this point. That's what Mr. Miller was saying when he's saying, there's been all these people saying forever that there was no such thing as a U.S. citizen, but only a citizen of one of the states, right? And we also have.
Miller goes on to say he as an individual, he must reside within a state to make him a citizen of it. It is only necessary that he be born and naturalized in the United States to be a citizen of the Union. How is that not referring to white people?
Well, that would be that's simple. If you want to naturalize as a U.S. citizen into a state as a state citizen, you would do it under the Naturalization Act of 1802.
What about born?
Born in a state.
This sentence explicitly says if a white person gives birth to another white person, that white baby is a U.S. citizen.
Where?
I just read it. It is only necessary that he be born or naturalized in the U.S. to be a citizen of the Union.
That's this one here. This one that I highlighted here. To be a citizen. Citizen of the. Okay, right here. He must reside. Yeah. The next observation is more important in view of the arguments of counsel in the present case. It is a distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state.
Again, I'm not disputing that you could be a U.S. citizen and not a state citizen.
But an important element is necessary to convert the former. So to convert the former, meaning U.S. citizen. No, former. The first thing you mentioned was the citizen of the United States. Into the latter, citizen
U.S.
of a state.
citizen into a state citizen.
Yes.
Okay.
He must reside, which would be the Naturalization Act of 1802, within the state to make him a citizen of it, as per exactly 5 years, was what it says in 1802, Naturalization Act. But it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union. Okay?
Yes. Okay.
That's you. It is quite clear then that there is a citizenship of the United States and a citizenship of a state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual.
Obviously.
Now, this is the part where I think he does the best job of clarifying between the two right here, right?
Uh-huh.
Of the privileges and immunities of the citizen of the United States and of the privileges and immunities of the citizen of the state and what they respectively are, we will presently consider, but we wish to state here that it is only the former which are placed by this clause under the protection of the federal Constitution.
Yes, he's saying
and that the latter, whatever they may be, are not intended to have any additional protection by the Amendment. If then there is a difference between the privileges and immunities belonging to a citizen of the United States as such and those belonging to a citizen of the state as such, the latter must rest for their security and protection where they have heretofore rested, for they are not embraced by this paragraph of the amendment.
Okay, I'll ask you, what do you think he's saying with those two paragraphs?
He's saying white people already had all this shit. None of this shit has anything to do with you guys. It's us trying to raise and protect the non-whites from all of the horse shit going on mainly in the southern states that are just horrible and it shouldn't happen in our country.
Okay. What he's saying is that the privileges and immunities clause of the 14th Amendment is there only to protect violations made by the federal government, Congress, and that it is not intended to protect. It is not intended to protect the privileges and immunities of the citizens of the state.
That makes no sense.
Law.
Why would they say that on the heels of 10 southern states doing horrible, awful things to release freedom?
Because Miller was an asshole.
No, Miller was no.
Yes, he was an asshole. He neutered the 14th Amendment. Again, that's why incorporation was needed to bring the protections.
Mr. Miller spent 20 years. He wanted to free the slaves
who are being violated by state laws.
You don't know anything about Mr. Miller. He spent 21 years. He was working as a doctor. He taught himself law. He released his slaves. He moved from a state that was very slavery oriented. He moved to another state that was more friendly. I think it was Iowa. When he moved, his slaves helped him move. And then as soon as he finished moving, he released the slaves. He started teaching himself law. He got into the judiciary. He was in the Supreme Court for 11 years. His middle fucking name, for Christ's sake, is Freeman. He was trying to release the slaves for like 21 years of his life, and you say he's an asshole? It doesn't make any sense.
Yes, he is an absolute asshole.
He's not an asshole at all.
Yes, he is. The only I think other scholars have said that the reason why he put this, he made this decision was in respect to Louisiana, because at the time this decision was handed down, Reconstruction was still in effect. There were still Union troops in the southern states, and so yes, and so there was almost equal distribution of whites and blacks in the state legislature in Louisiana, and he felt that if he argued that
the military was trying to push out the Confederates.
If it argued that the Privileges and Immunity Clause didn't apply to the states, then it could affect the majority in the state house, in the state legislature in Louisiana. But either way, I don't know how
it's crazy and makes no sense, because the black people were trying to get federal help because they were in trouble in the states, not the federal government was not attacking the blacks.
Cases, they got fucked.
They didn't get fucked. They got the exact protections they wanted.
What was Jim Crow?
Well, Jim, it was 100 years of them trying to get this stuff applied, and it was very difficult because of the separation of powers between the states and the federal government.
But Jim Crow lasted this long because of, in part, the slaughterhouse cases.
The slaughterhouse cases, it doesn't make any sense. Why, if your theory is correct, why would the blacks need protections from the federal government? The federal government wasn't doing anything to the blacks. It was the states.
Right, and then the Union troops were there to protect them.
Just common sense make no sense.
And then by virtue of the slaughterhouse cases, it effectively meant that a black person could not sue in federal court against a state law that he felt was violating his federally protected constitutional rights.
No, that's the whole 42 U.S.C. 1983. That's the whole purpose of 42 U.S.C. 1983 and 85. That's the whole fucking purpose, was to give the blacks federal protection from state atrocities. That was the entire point. Look, 42 U.S.C. 1983.
It didn't stop any of the states. It did not stop the states from segregation or Jim Crow.
Okay, you're talking about effectiveness. I'm not even talking about effectiveness. I'm talking about just effect.
Let me ask you.
Just effect. Now, hold on. 42 U.S.C.
USC
1983 Civil Action for Deprivation of Rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution. Now, the caveat here would be any incorporated immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act, blah, 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 blah. This, now check this out. Now check this out. So if you have this, now let's look at 4 U.S.C. 71. Where is the permanent seat of government? We all know that. All the part of the territory of the United States, included within the present limits of the District of Columbia, shall be the permanent seat of government of the United States. Okay, fine. Okay. Now let's look at 4 U.S.C. 72. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. So the whole point...
What do you think that means?
It means that anything that's within the exclusive territorial jurisdiction of the United States, which would be certain offices or certain parks or certain ports that may be attached to the seat of government, shall be exercised in the District of Columbia and not elsewhere, except as all federal courts essentially fall under 4 U.S.C. 72.
That's incorrect.
That is not incorrect. That's why that's the whole point of federal.
No.
Federal means the District of Columbia. How can federal not mean 4 U.S.C. 71? That's what federal means.
Do you not know what federalism even is?
Yes.
So but you understand that there are laws. You understand that the law. Are you literally telling me that the laws of Congress, from healthcare to immigration to their criminal statutes, all of that only applies to like the 3 square mile of D.C. and Puerto Rico and Guam and whatever?
Exclusive territorial jurisdiction of the United States.
No.
Exclusive territorial jurisdiction of the United States.
Again, you completely ignore the concept of concurrent jurisdiction, but I mean, I don't know how I can...
Concurrent jurisdiction would have to be established above and beyond the idea that it's not within the exclusive territorial jurisdiction.
Right, and federal laws apply to all the different several states.
No, federal laws apply if you can gain federal jurisdiction, which would be federal question, diversity, etc. You know, 42 U.S.C. 1983 does not have
concurrent jurisdiction.
42 U.S.C. 1983 claims do not have by themselves a federal jurisdiction, but did you know that 42 U.S.C. 1985, which is the conspiracy version of 83, does have its own entirely separate federal jurisdiction code? Did you know that? So an 85 claim would be under the exclusive territorial jurisdiction of the United States, whereas an 83 claim would not. They would need to establish diversity or federal question.
Wait, so why is 1980 if all federal laws are only applicable to, D.C. and Guam and Puerto Rico, what
all the U.S. territories and insular possessions?
Yeah, why would Section 1983 apply to the states?
It's a federal protection for non-whites being fucked with and attacked in the states.
But again, you told me that if it doesn't have exclusive jurisdiction, federal law doesn't apply.
Well, it would be a federal question. It would be under the idea of
No, I'm sorry. You're walking back now. You told me that the federal law does not apply when it doesn't have exclusive territorial jurisdiction over a territory, aka Puerto Rico or DC or Guam.
But now you're saying that 1983 can apply to the states.
Well, the idea of the cause of action being a federal question would apply under, was it 28 U.S.C. 1331? I think it's a federal question, or the diversity. I forget. Now from there, you would have to go into establish further jurisdiction over the parties. So at that point, would both parties be under the exclusive territorial jurisdiction of the federal government? So there's like 2 layers to it. So you would have a federal question, but then you have to now move into, do you have exclusive territorial jurisdiction of the parties? For example, a state citizen that's not a U.S. citizen, they wouldn't be able to establish that necessarily. That would be under diversity. You'd have to go under diversity for that. Diversity specifically says 28 U.S.C. 1331. No, is it 1332? Yeah. Diversity specifically says in subsection A1, citizens of different states.
Yeah.
And it has to be at least 75,000 as well.
Okay. I don't know how this furthers your argument here.
I don't know either.
Again, you keep telling me that federal law does not apply to the states.
Well, it needs to be established above and beyond the exclusive territorial jurisdiction of the United States. So exclusive territorial jurisdiction means like practically ownership. U.S. territories and insular possessions are practically just owned properties of Congress. The states are not owned property of Congress. They wouldn't fall under the exclusive territorial jurisdiction of the United States.
And the states are considered sovereign, and the states are considered sovereign entities. So
correct. So what would it fall under? The Commerce Clause.
So the feds can only apply laws passed by Congress to the states if they are within the specific confines of Article 1, Section 8.
I don't remember what that is, but yeah, sure, fine.
Article 1, Section 8 lists the various subjects of what Congress is allowed to regulate.
Oh, yes. Yeah,
so Congress can establish taxes that are applicable to the states and state citizens. It can apply various regulations, post offices. All of these things are the specific subjects that the Congress can pass, and they apply to everybody, state or non-state.
No, I can prove that's not true. Let me just pull up the legal tender cases, because they cover this a lot in legal tender cases. If we go to, because this is exactly how they created Federal Reserve notes, actually, what you're talking about right now, right? So if we go into...
Congress has the exclusive right of coinage. Yeah.
Yeah, but the way they describe it, the legal tender cases is absolutely fascinating, because they actually do a really great job of delineating the 2 differences. Let me see if I can just rapidly find this. Actually, you know what? It's in one of my cases. I can pull this up. Let me just pull this up here. This is from a reply brief that I filed in to an appeal. Let me see if I've got it here.
Is this the one where they identified your arguments as being sovereign citizen?
I mean, that's pretty much all of them.
Yeah.
Let's see here. Not that I give a shit, because I go the Roger B. Taney definition, and I love being called a sovereign citizen. It makes my dick hard.
So, okay, so you're conceding that the courts are identifying your arguments as tried, tested, and found wanting, and are full of shit.
No. I've changed a lot of it over and over again.
Yeah. That's exactly right. What's the prompt of the debate? He just arguing about law. This dumb motherfucker who doesn't know shit about the law is arguing with a seasoned professional lawyer.
And it's starting to get better. I just got to figure out, my main issue is procedure, but I'm getting a lot better at it.
Yeah, but in any one of your cases where the court has actually made a decision on the merits, they've all said that this is bullshit.
No, I've never.
It's been proven as.
I have never ever had any of my cases decided on the merits ever. It's all procedural.
The motion to dismiss.
Yeah, well, it's procedural because we never even had a hearing or anything. I never had a chance to really talk at all, and they said nothing.
In that one case, did you guys not have an actual oral hearing?
I have literally never, NEVER, ever had an oral hearing in any of my cases, ever.
So then which case did I look at where there was an actual transcript of an oral hearing? Was that one you didn't participate?
Yes. That's not mine, me personally, no.
Okay.
That's another case. So I found it. Here's the case. It's they're talking about paper money theory, right? So
yeah, that's where they say that they
it's a joke. It's just pure ignorance. It's literally, I'm a retard. Paper money theory. I'm a retard. So look.
Yeah, they think that you could get money for nothing.
They don't even know what money is. Anyways, Juilliard v. Greenman.
Money, Federal Reserve notes, fiat currency,
we're not going to get into all that. We're not going to get into all that.
Whatever you use to pay your rent or electric bill.
We're not getting into that. I'm not going down that rabbit hole right now.
I know
way
you
too
don't.
much.
I know you don't want to.
Use it as, fine. I don't want to add another hour to this and start talking about that bullshit. We're not talking about that bullshit right now. You don't know what money is. Nobody knows what money is. It's fine. I get it. I'm over it. So Juilliard v. Greenman, and we're going to learn what money is here in just a minute, a little bit at least. So by the Constitution of the United States, the several states are prohibited from coining money, emitting bills of credit, or making anything but gold and silver coin a tender in payment of debts. But no intention can be inferred from this to deny to Congress either of these powers.
Okay.
It appears to us to follow as a logical and necessary consequence that Congress has the power to issue the obligations of the United States in such form and to impress upon them such qualities as currency for the purchase of merchandise and the payment of debts as accord with the usage of sovereign governments. The power, as incident to the power of borrowing money and issuing bills or notes of the government for money borrowed, of impressing upon those bills or notes the quality of being a legal tender for the payment of private debts, was a power universally understood to belong to sovereignty in Europe and America at the time of the framing and adoption of the Constitution of the United States.
What is it? What are they saying there?
They're saying that the states can't create and have something, a negotiable instrument. So a Federal Reserve note is a negotiable instrument. It's not gold and silver coins. It's not even a promise to have gold and silver coins.
A state cannot issue its own currency.
The word currency includes negotiable instruments. The word money does not include negotiable instruments. Two totally separate terms.
But a Federal Reserve note is considered money.
No, a Federal Reserve note, and I can prove that very, very easily. It is absolutely not.
Okay, so
if you go to, hold on.
Congress. So
let me show you. Let me prove it. Let me prove that. Hold on. Let me prove it. Stop. Let me prove it. Let me prove it. UCC 3-102. This article applies to negotiable instruments. It does not apply to money. And they cover that a lot more in UCC 3. Money.
I don't know why.
Totally
I know you have a hard on for UCC 3. I don't know. I don't understand why. But
fine. Then you don't have to understand why. That's okay. I don't mind if you don't understand.
Okay, but neither does the court, and the court doesn't care about your arguments about UCC 3.
Well, that's not true. That's not true. We haven't established anything that really even covers it yet. So no, that's not true. I mean, okay. I'm 39 years old, bro. I ain't going anywhere. Like, you think I'm not gonna be banging on this door for 10 fucking years? Like, they're gonna open it eventually.
Sure.
I mean, we'll see. Maybe they won't. I mean, that's fine.
I'm having a blast. On that.
Yeah, fine. So, anyways, here's another section. We have oh no, that's not it. This one here, right? So there was no coin. They call it specie. This is like the technical term you'll see a lot in a lot of the cases during the legal tender cases. Specie. That's referring to gold and silver coins, which is money, and it's totally different than what you have in your wallet, which isn't money, by the way. In general circulation in the United States between 1862 and 1879, both gold and silver were.
Yeah, you heard it here. Money isn't money, right? This right here, this stuff right here, it's not money. It's just not. Because some dumb motherfucker doesn't know how to read information.
Treated in business as commodities. This is the same thing we have in today's world. So ever since 1933, gold and silver coins are treated as commodities, and they removed them. Now, negotiable instruments have been considered the same as cash for ages in our country. I mean, I have all the way back to Swift.
Right. And then I understand what you're saying. And then I think in one of your first case, you argued that a purchasing agreement was a negotiable instrument.
Well, the very, very first case that I have listed on Williams & Williams is pretty rough. I literally had no previous training. I just dove out of the plane, basically without a parachute. So I'm not going to sit here and talk about my first few cases. I'm not going to. They're really not very good, frankly. So I learned just literally from like sheer like battlefield experience. So I'm not going to sit here and say that my first mini cases were really any good, frankly. I'm not going to say that. But I'll tell you right now, I've been doing this for a little over a year and a half, and there ain't no motherfucker on the planet that's learned this much shit this fast.
And when you
I need more time.
When you find stuff on the internet, I mean, when you find tried and true sovereign citizen arguments that have been in place since the 60s, of course you're going to learn a lot. I mean, if you go down the rabbit hole. No.
I'm trying to get all this stuff going. I've been trying for a year and a half, and I need more time, but I'm doing it. I'm getting there.
Getting where specifically?
To the point where we start getting into making it past a motion to dismiss, or getting into discovery and getting into the merits of the case. I've never really gotten into the merits of any of my cases.
With the goal being that you can get out of your mortgage payments by having the Treasury Department pay for it.
No, that's not at all what I do.
Yes, that's exactly what you do.
Certain things are negotiable instruments under UCC 3-104, and certain things are not. It just depends on you have to analyze each document individually to see if the document falls under 3-104 or it doesn't. That's the definition of a negotiable instrument. So I don't. So you can't just say generalized things and then expect me to. If you have a promissory note, which is defined as an unconditional promise to pay as per UCC 3-104, then yes, it is a negotiable instrument.
It would be a purchasing agreement, right?
A purchasing agreement, if it's an unconditional, well, it depends. If there's a condition to payment, which would fall under 3-106, a condition to payment, a purchase agreement would be like, it depends on how it's worded. So if you have a purchase agreement that says, on this date we'll deliver, and then once we deliver, you have to pay us, that would be a condition to payment in accordance with 3-106. That would not be a negotiable instrument. That would not be a promissory note legally.
Right. So, and as somebody who went through the process recently on selling a house, I can tell you that vast majority of purchasing agreements for real estate almost always have conditions to them. So I don't know why you would ever think that was a negotiable instrument at all.
Well, keep in mind, Artie, you went to law school, you did all this stuff. I literally.
For the same reason he thinks his bullshit license plate won't get people pulled over.
Literally just jumped out of a fucking plane. I filed a federal case and just didn't even have a fucking parachute.
Do you not think that that's kind of like a risky thing to do for another person who's dealing with real estate that can possibly cause millions of dollars, as what was alleged in the agreements?
You'll need to reread the question. I don't understand the question.
Do you not think that that is a huge risk to jump headfirst into something that you admit that you're not really knowing much about what you're doing in a very contentious purchasing agreement with homeowners who are dealing with property that are worth millions of dollars? And
do I think it's
consequences
risky?
Of failing to close on a house can cost them a lot of money, right?
I'm not entirely sure exactly how to answer your question. I love risk. I love motorcycles. I love women.
Well, it's not just your risk; it's the risk of your clients, for lack of a better word.
What kind of person do you think would hire someone like me to do this kind of shit?
A fucking moron.
An idiot.
Fine. Somebody who likes risk. That's for damn sure.
Okay. I mean,
if risk makes your fucking dick hard, I'm your guy. I don't deny it. I'm not saying that ain't true. I'm not denying. I'll tell you straight up. If you like risk and it turns you on, I'm your dude.
And I guess they paid for it, right?
Oh yeah.
Yeah. And you hold yourself without any responsibility for what happened to that deal that fell through.
Oh, absolutely. He doesn't hold himself responsible. He just gives the information out for a donation, and they accept the risk.
So what we do when you say so, what deal that fell through? What do you mean by responsibility? What do you mean exactly?
So my understanding from your very first case, it involved.
I hate that we're bringing up the first case, just by the way, because it's just a really shitty case.
Purchase or sale of real property, and the folks there in the middle of the purchase or sale, they went to you, where you argued that the purchasing agreement, which in my terms, when I was doing it, I was under contract for the sale of a home. I assume that's what we're meaning of a purchasing agreement. Said that contract, that agreement in and of itself could be exchanged for cash.
Well, first and foremost, a negotiable instrument by itself is cash. So when you say exchange for cash, it's not really a negotiable instrument. Is cash. You can convert one type of cash to another type of cash. Now, hold on. I thought that those instruments at that time were.
How?
Because I thought they were unconditional promises to pay or unconditional.
Have you never bought or sold a house before?
No, of course not.
So that's what I'm talking about here. If you were an actual attorney, you would be put up for malpractice.
I mean, I don't know how many attorneys you've dealt with, but the amount of malpractice, you say that, but no, they wouldn't probably, honestly.
If I were to advise my client that a purchasing agreement, while the sale of the house hasn't closed yet, could be exchanged for cash, and try to force the title company to do that, yes, I would be put up for legal malpractice, and I probably would have my license suspended.
Okay, I don't know what to tell you. I mean, like I said, it was. I never went to school. I just went straight into.
I know. You never went to school. You dove headfirst, as you mentioned. Yeah. You're going in blind. So
I don't. So you're from your perspective, you're saying after having done this for many years, after having gone to school, after having done this, it doesn't make any sense why you would X. I'm not telling you it did make sense. I'm not telling you it should make sense. I'm telling you I was a guy who jumped out of a fucking plane and that was it.
And so I guess all the responsibility and the consequences are on the people who took your advice.
I mean, a lot of that stuff is still ongoing even to this day. I mean, there's so many other things that have happened since then in other cases, and we're still in the middle of all sorts of different things with it. A lot of it's posted on the other cases. So when you say responsibility, I don't know exactly what you're referring to.
Someone needs to sue this motherfucker.
A lot of all of that stuff and all of those cases involving that particular person is all still in progress. So I'm not too sure. So if your definition of responsibility was, are you sticking with it and ensuring that you take this thing to a final product or that you achieve closure, the answer to the question is yes, I'm still doing it to this day, and we haven't completed that process.
Well, I think is the case not effectively moot? Didn't the sale of the house fall through?
Yes, the sale of the house did fall through. Yes, it was already pretty much fall through when I arrived. It had already kind of fallen through by the time I had arrived in the scene.
Okay, so then.
You use the word responsibility. It's just really hard because everybody seems to have a different definition of that. If you use a different term or idea, I could probably do a better job of answering the question. Like,
I would say
if you were more specific and you were like,
a licensed attorney has a duty to act in their client's best interest and to provide them with the advice that would serve your client's best interest. And I would say that a base level of understanding of negotiable interest and contracts for real estate, it's obvious that a purchasing agreement is not a negotiable instrument that you can take it to a bank and get cash for it.
Yeah, I'm not denying
what the purchase is for.
I'm not denying the fact that that was a disaster. I mean, it literally was a disaster. I mean, it's not anything that we haven't handled since. It's all wrapped up into a nice little bow now today. But at the time,
you could say that your subsequent cases have not really been successful.
It depends on how you define successful. If you define successful as winning through
on the merits,
no, I've never really gotten into the merits on almost anything. No.
Well,
and the reason behind that mainly is procedural. I have had a lot of procedural. So the timeline is really weird and goofy. So the first year, I wasn't even reading case law. I was just pure horseback raw dog in the whole thing. And then by December, I was so defeated and so beaten down that I said, all right, I'm going to finally start learning procedure and I'm going to finally start reading cases, which I know sounds absolutely insane to you, but that's just the truth of what happened. In December is when I started reading a lot of cases. And I was reading cases like crazy. I kind of fell in love with it. I fell in love with the story and the history, and then I started researching a lot of the background of the various Supreme Court guys, like, for example, obviously Taney, John Marshall, Mr. Miller. I started getting a lot of their histories. I just found the whole thing fascinating, right, in the history of the United States. And then started getting into procedure more recently, probably in March, April is kind of when I started getting into that. Procedural, I was very naive and very headstrong in thinking that I could somehow get into the merits of the case without really knowing anything about procedure, which is, I know to you, that's going to sound like the most batshit thing you've ever heard in your life.
Yeah.
That's just, I don't know what, it's just a fact. I don't know. You can make fun of me for it. Fine. I don't even disagree.
I would say that I would be hard pressed for you to put yourself out as a law firm or a law group if you don't have the base level knowledge of federal rules of procedure.
Well, now I understand that. But you also have to keep in mind too.
But you took on clients when you didn't understand that.
Well, the idea of taking on clients in your world is very different than in my world. I have a power of attorney, an international power of attorney, and
Which doesn't make
there's no such thing as international power of attorney.
you a lawyer, right?
Well, it's attorney in fact would be the legal term.
No, there's no such thing as attorney in fact. You can't be an attorney in fact. You can't just call yourself an attorney and say, I'm an attorney.
Right, and I put that everywhere. I don't put attorney at law anywhere. I don't put attorney at law anywhere. How's the word attorney?
Right, but you're practicing law.
No. The definition of practice law means making an appearance on behalf of a plaintiff or a defendant.
You are helping clients.
I have never, ever made an appearance on behalf of a plaintiff or defendant, except my sole proprietorship.
Except when you try to interject yourself in a hearing in that first case, and the
plaintiff
tried to file a motion to compel the defendant's attorneys to talk to you or to respond to you. So
yeah, but
no,
that wasn't.
That's
not an appearance. That's not an appearance. I did not make an appearance.
Actions. You filed memos.
I did not file that. I did not file that. I did not file. I have never, ever filed anything on behalf of a plaintiff or defendant. That's not me, except my sole proprietorship. I assure you, I will sign an affidavit under penalty of perjury right now.
Why were you trying to get yourself to be taken seriously by defense counsel?
The client filed a motion to compel communication with me.
But my understanding is that the defense counsel said that they wouldn't talk to you, but they would allow you to listen in on a conversation between the plaintiffs and yourself. So you did appear. They just didn't
no. In a private conversation that has nothing to do with.
I'm sorry. I don't think you understand that you don't have to actually physically enter a courtroom to be acting on behalf of a client.
No. The definition of the word appearance means filing something on behalf of or speaking on behalf of in a hearing or any sort of on behalf of.
Which you tried to do, and defense counsel said, no, you're not an attorney. We're not obligated to talk to you.
But the idea that the client filed a motion to compel communication and the idea that motion to compel communication was denied, none of that or anything that happened before it or anything that happened after it would be legally classified as me making an appearance into anything. I never made an appearance.
Even though the judge in that case explicitly said that you were practicing law.
Yeah, but here I am, and it's just horseshit. I wasn't, because the thing, practice law, I would have to make an appearance. I never made an appearance.
But you were giving them legal advice, were you not?
That's not making an appearance. That wouldn't be practicing law as per the definition.
Giving legal advice is in part practicing law.
That's under the whole U.S. citizen. You have to be a resident of a state. That's under the business and professions code.
I know that goes into your whole thing that you get out of jail free card is your whole thing. Oh, I'm not a resident of the United States, even though I'm literally living in California. But that's not how the world works.
The word domicile I just showed you. It's used even by the Federal Bar Association in terms of their relationship with the District of Columbia.
So are you domicile or are you a resident of California?
I'm domiciled. I've never been a resident of California, ever.
What does your birth certificate say?
I don't have a birth certificate.
You don't?
Bullshit.
Oh, you don't have a social security number?
Bullshit.
Nope. Oh, I bet you do. I think you do. But
fine, then you prove it. You see how that works? You prove it. Fifth Amendment.
If you were born within the territorial confines of the United States,
you prove it.
You likely have a birth certificate.
You go out and find all the evidence and submit it, and then I'll file an opposition. We'll play that game.
Well, I mean, are you worried about ICE coming to your door?
No, not at all. Not even remotely.
Why not?
I'm the whitest guy in the world. I'm like a ghost.
You know there were white Hispanics, right?
Yeah, but dude, I'm literally fucking albino, bro. I'm a fucking.
You never met my dad, and I'm Puerto Rican. So
the color, the lighting in the room is a little bit yellow. I can tell you have a little bit of a tint to your skin. Look at me, bro. Look at me, bro. I'm trans fucking lucent.
Okay. So you're not worried about ICE because you passed.
Well, keep in mind, I have this. I am filing a writ of certiorari. Like, I am very excited. I put a lot of time and effort into this. I went and printed all the booklets. These are the booklets as per the Supreme Court rules. And I have, you can't see it. I have a couple boxes right here. I don't know if you can see it. Those are all of these booklets. And I've got the word count. I got to print that up. I got to get the cashier's check tomorrow. I've already got the Solicitor General of the United States. He's already being served in 2 different ways because the process server couldn't get into the building. So I sent everything certified mail, and then I also gave her a different address. So this bad boy is getting filed real soon. Like, probably in the next 6 or 7 days, this thing is going to be in the mail. So keep in mind.
I mean, that's really cool and all, but I think you understand what the odds are of whether or not this court is going to take up your case.
Dude, maybe 1/5 of 1%. I understand that. But I tell my audience that. I'm very clear about that. I'm not delusional. I totally get it.
Okay.
But the thing is, I'm doing it.
Yes, you are filing actions, and anybody can file an action in federal court.
Well, have you ever filed a writ of certiorari? Bro, this shit's fucking insanely complex. They have special dimensions for the paper. It has to be a minimum of 60 pounds on the inside. It has to be a minimum of 65 pounds for the cover. It has to have a minimum of 2 staples. I have to put tape over all the staples. I mean, fuck, dude. I mean,
yes, formatting rules are a pain in the ass. I understand that very much so.
In the Ninth Circuit, when I was in the appeal, that was super easy. They gave me a pro se template, and it was like Sesame Street retard shit, and I just filled it out, and it was great, right? And I get into the Supreme Court, and it's like, oh my god,
that's a good question. Why are you? That's actually a good question that I just saw in chat. Don't you need to actually be specifically admitted to file actions in the SCOTUS?
No.
Are you sure about that?
Yeah, it's all through the rules. It's all through the Supreme Court rules.
I'm pretty sure you need to be specifically admitted by the Supreme Court in order to file actions on behalf of a client.
Oh, on behalf of a client, yes.
And pro se. I don't know if they allow pro se, but I have to double check that.
Yeah, they call it an unrepresented party. Terminology is a little bit different, and they also use the term pro se as well. You can check the rules. I'm doing it. You can check the rules. $300 fee, filing fee. You can pro se your ass all the way to the top, my brother.
Sure. Man, I don't know where we left off, but it's we're about close to 2 hours here. So
anything else you wanted to bring with you, or anything else you wanted to ask, or anything? I mean, you can look at my writ of certiorari, but a lot of it is just the treatise on the word person minus all the colorful language, essentially. If you want to,
right?
I mean, to some degree.
I think ultimately, we're kind of at an impasse. I think we obviously have fundamental disagreements on the interpretation of the slaughterhouse cases, what the effect of the slaughterhouse cases was in terms of constitutional law and applicability to.
I don't think anyone agrees about what the slaughterhouse cases says. Hardly all.
I think there is a general consensus on what the results of the slaughterhouse cases are.
Barely. I think it's the one case that has the most amount of contention.
I think the most obvious one is the one that you disagree with the most, which is that it effectively neutered the ability to apply the Bill of Rights to state laws until incorporation. Now,
what's funny is dumb pieces of shit like this and flat earthers are the same side are opposite sides of the same coin. But the thing that sets these people apart is these people bet their freedom that their dumb shit ideas are true.
Over the years, walk back that decision. But again, I think that's a fundamental disagreement that we have in terms of the results of the slaughterhouse cases. I think we have a disagreement on, the nature of person.
Why would white people who are already citizens tell Congress to take away their Bill of Rights and then incorporate them later? It doesn't make any sense. Take away my Bill of Rights, please. Why would we go to Congress and say, Congress, please take away our Bill of Rights and then incorporate them later? I mean, the Second Amendment wasn't incorporated until 2010.
Right.
Yeah, white people did. The way they pitched it, a lot of these guys like Thaddeus and fucking John and all these fucking guys are all white guys. So
right.
A lot of white guys doing this.
Again, that goes into our fundamental disagreement, where I am arguing that the intent of the 14th Amendment was to bring non-whites to the same level as whites as U.S. citizens, but you have a disagreement there.
No, we've already covered that. That's also what Thaddeus said and John and all those guys. That's exactly correct. But the thing is that it was so there was one elevator, there was one class, and that's in Dred Scott. He covers that really pretty good, right? And keep in mind, I don't think you like Tandy very much. He was already the Chief Justice for 21 years by the time Dred Scott came out. And if you actually read the case, you'll see the amount of research and historical information in that case is unbelievable. They go all the way back to the English Empire, and it's very detailed. And you know that Tandy got rid of his slaves in 1818, and he actually hated slavery.
Well, when it comes to Dred Scott, I'm going to say it here, and maybe I don't know. I don't think it's going to be controversial to my audience because I think my audience understands me. I understand that at the time of Dred.
It sounds to me like this dumb fuck learned more about the history of the people behind the decisions than he ever did about the decision.
At the time of Dred Scott, I'm not necessarily disputing Tandy's interpretation of the Constitution as it was written at that time and the origination of the Constitution at that time.
Okay.
I'm not disputing the majority opinion in how they interpreted the Constitution at that time. I'm just arguing that the 14th Amendment ultimately overturned Dred Scott, or at least it was confirmed to be overturned
in the slaughterhouse cases.
In the slaughterhouse cases. So yeah. I'm not disputing the majority opinion necessarily as it was interpreting the Constitution at that time.
Okay, that's cool.
See, a lot of people are just smart enough to be dangerous. That's to themselves. This guy is just smart enough to be a danger to other people.
I think Tandy was brilliant, and I think that he was such a professional because he had an emotional opinion that slavery was horseshit and it needs to go. but he pushed aside his own emotions and he pushed aside his own opinion, and he gave his opinion based off of the facts and based off of the wording and based off of the original intent of the congressional Congress, the people who wrote the Constitution, and he left his own opinion, his own emotions out of it, because if his own emotions and his own opinion would have been injected into that final opinion, which I think around half of the Supreme Court justices were slave owners at that time that opinion was issued. So. Okay. I think he's a man of extreme professional attitude who keeps his emotions and his opinions outside of his work, and for that I think he's an absolutely amazing person and an amazing American, and I think he did a great job as the Chief Justice. And I think the idea that his name was completely destroyed after serving in our fucking Supreme Court for 28 years, dying practically in the fucking courtroom. They were giving him whiskey mixed with water at the very, very end in October of '64 because he was so fucked up. He was still fucking working even during that time period. He could barely even fucking walk and died.
I obviously, you have a very high opinion of Tanny. I mean, okay. I have a high opinion of
Miller too. Miller was the total
opposite one way or the other. I'm just saying that Tanny, I don't think that Tanny was necessarily incorrect on his interpretation of the Constitution at the time of Dred Scott, but I can say with ease that his interpretation of person and people was ultimately overturned and overruled by virtue of the 14th Amendment and the slaughterhouse cases. Again, that seems to be our fundamental disagreement that we're having here.
The words people and persons were not something that was attached to Dred Scott versus Sandford, of which could have been overturned. Those definitions were constitutional definitions. The idea that Dred Scott was overturned has nothing to do with the differences in definitions between the definition of the word people and the definition of the word persons. Well, he says...
Well, the 14th Amendment got rid of that distinction.
No, he's not saying I think or we think. He's saying in the Constitution there are clearly two places where they say the Negro race is a separate class of persons and was not intended to be a part of the original document. He's saying,
and then he later on goes to say that the 14th Amendment got rid of that distinction. That was established in Dred Scott.
Okay, fine, but that distinction wasn't established in Dred Scott. It was established in the Constitution. The word people is in the preamble, and the word persons is in the slave trade clause.
And the 14th Amendment got rid of that distinction.
No, how can you get rid of the constitutional distinction? No.
Amendments can change
now, keep in mind,
words.
The definition of the word amendment does not mean we're going to come and slaughter all the Bill of Rights and then we'll give them back to you.
Nobody's saying that the 14th Amendment slaughtered the Bill of Rights. It's saying that it eliminated this distinction that was invented or created by Dred Scott, that was outlined by Dred Scott. That there's no longer this
distinction. It did exactly what you said earlier. It raised the blacks originally, but it was meant to be for all non-whites, to try to bring them up to the same level. The intent was really good. That's not actually what happened because of the incorporation doctrine and because of the idea that Congress was given the ability to give which Bill of Rights they wanted to the U.S. citizen class and which ones they didn't, which became the incorporation doctrine. And there's been times throughout the past, during that time
I'll be right back. I got to pee.
Period, where they were like talking about how the original...
Hey, mushy, yeasty engine. Okay. Glad you're here. Hey, what happened? Oh. Be right back.
Intent was to give the U.S. citizen class all of the Bill of Rights. There's actually cases where they talk about that, and they're like, no, but the court just never really went with that.
But the U.S. citizen, by virtue of the 14th Amendment, did get those Bill of Rights.
No, they didn't.
Yes.
I can prove that one to you.
They were only protected, but they were only protected by laws passed by Congress, not by the states.
No, I can prove that one.
That's the slaughterhouse cases.
Check this out. It's in the treatise.
I'm sure it is.
U.S. versus Valentine. It's a great case. Now, this case was from Puerto Rico, which makes perfect sense.
I know.
Right? The only absolute and unqualified right of citizenship is to residence within the territorial boundaries of the United States. A citizen cannot be either deported or denied reentry. That's it.
Okay. And
he's exactly correct.
Therefore, you think that the Bill of Rights do not apply to U.S. citizens at all?
It applies via the incorporation doctrine. Via the incorporation doctrine.
Are you telling me that until the incorporation doctrine came about, the Bill of Rights meant nothing?
That's correct.
Okay.
Well, for U.S. citizens.
All right.
And that's why you and I, because why would white people give that ability to Congress? You see, it wasn't for white people. It had nothing to do with us. It had nothing to do with people. It only had to do with...
God damn, he is dumb as fuck, isn't he? He is dumb as dog shit.
Persons.
Persons includes white people. I know you think that it means... I know. It contradicts your entire worldview.
Now, if you want to get really technical, if a white guy is in Guam, Puerto Rico, or the District of Columbia, then he would have no choice. He would either be...
Then suddenly becomes a person.
Then he would be a person's class. That's correct. But
so persons is now itself its own class.
Well,
is a person? Well, hold on. Is a person so a person is a U.S. citizen?
No, persons.
But they're also a subclass of a state citizen. You mentioned earlier.
No, that's okay. So the whole subclass of a state citizen thing being a resident, that's something that I'm currently looking into and trying to collect more information. So, for example, on that one, I can show you a little bit of what I'm currently collecting on that. That has to do with the whole military occupation and how they forced. So, if you look at like a lot of the state constitutions,
All right, the Third Amendment takes care of that.
you have new constitutions that were coming out around that same time period in almost every single state. And so I started thinking that was kind of weird. So I started looking into it, and it has to do with the military occupation. And basically, in the military occupation, they said that you can't become part of the Union until you do certain things. And inside of those certain things that they were trying to get them to do is really where a lot of that information is located. But I just haven't had time to. That's all brand new. I haven't really gotten into that too much. But I can show you, kind of what I have so far. I can show you what I have because this is.
Oh God, Ackerman, don't. Just don't.
This is like, I just put this on here like yesterday. So, and it's all connected.
But if you do, film it.
With, yeah, here it is. So, this is an interesting conversation too, because you got to think like, how is the 14th Amendment considered legally ratified when all this shit was going on at that time period, right? So, Congress passed the first Reconstruction Act on March 2nd of 1867, which dissolved the existing Southern governments, except in Tennessee, which had already ratified the 14th Amendment and been readmitted into the Union in 1866, and imposed military rule on the remaining 10 former Confederate states, all listed here.
Okay.
These states were divided into 5 military districts, each overseen by a U.S. Army general appointed by the president, which I think was Abraham Lincoln at the time. The military commanders were tasked with maintaining order, protecting the rights of freed men, former slaves, suppressing violence from groups like the Ku Klux Klan, registering eligible voters, including black men, but excluding many former Confederate leaders. That's interesting. And supervising, supervising, in quotes, I should put that in, I'm not going to put in quotes, elections for state constitutional conventions. Right?
Wait, so now you're disputing the validity of the 14th Amendment?
I'm not the first one to do that at all.
I know you're not the first one. I'm asking if you are.
Well, yeah, of course. I mean, look at this. I'm going to read it to you right now.
All right. So does that apply to the 13th Amendment too?
Well, hold on.
Is it 15th?
Hold on. Let me read this.
I'm asking you. They were all passed relatively soon from each other.
I know. This military occupation effectively placed the South under federal martial law, with troops enforcing Reconstruction policies amid ongoing resistance, including race riots and political intimidation. The acts specified. Now, keep in mind, the Civil Rights Act was passed around the same time.
I know you were joking.
Time period again, and the 14th Amendment was also pitched at around the same time period after this. So again, the idea that they were trying to they needed protection from the federal government is the stupidest fucking thing I've ever heard in my life. They needed protection from the states, not the feds. The act specified clear conditions for these states to be readmitted into the Union and regain representation in Congress.
Why I think the slaughterhouse cases was bullshit and was an idiot position.
Okay.
Because he neutered the 14th Amendment in applying it to the states.
I don't think that's true at all. But anyways, let's continue here.
But again, you only need to look at. You only need to look at Jim Crow and Plessy to demonstrate that. But
great. So let's continue with this. Hold constitutional conventions with delegates elected by all adult male citizens regardless of race, excluding those disqualified for participating in the rebellion. Draft new state constitutions. So this is where we start seeing all these new state constitutions in the southern states that guaranteed universal male suffrage, which means voting for the people who are watching, including for the newly freed Negro. Ratify the 14th Amendment, which they did not want to do.
You didn't have to say voting when you said suffrage for smart people. Notice for those people in my audience that don't understand shit.
And that's why they had to push out a lot of the Confederate people and make sure all the blacks signed up, because they did not want to pass that thing at all. They were going fucking nuts.
Well, yeah, no shit.
Receive congressional approval of the new constitutions by a majority vote in each state. Now, how in the flying fuck could anyone consider, under these circumstances, that the 14th Amendment was legally ratified by these 10 states? It's just ridiculous.
They lost.
It's ridiculous.
Too bad, so sad.
If I put a gun to your fucking head and I say sign here or you die, how is that legal?
Because it was ratified.
I mean, it's presumed to be. Yeah, it's presumed to be.
And it's been established law ever since. Never been overturned, never been challenged.
It's been challenged.
I know you guys like to do this with the income tax amendment, but no. I mean, have you ever actually asked yourself why a lot of sovereign ideology revolves itself around the 13th, 14th, 15th amendments?
What is wrong with this guy's mouth, man? What the fuck? His face contorts more than a long-term meth user.
Have I ever asked myself why? Because that's really where the conversation of what citizenship really is took center stage. Up until that point, even in Dred Scott and Slaughterhouse, the idea of what a citizen was apparently just wasn't much of a concern prior to 1857.
You don't think that there may have been a lost cause, a racial component as to why people have with this ideology have such an issue with these amendments?
I mean, obviously, there are people who have been in. I mean, I guess the better question would be to ask, do you really think that I fit into the typical sovereign citizen mold that you typically see or talk about on your channel?
Yeah, you do. You most certainly do.
Channel. You've even talked about that on your shows about me, that I'm totally unique and different than almost anything.
I would say your distinctions between person and people and how it's white people versus non-white is something I haven't heard of. But ultimately, at the very end, your interpretation of the 14th Amendment and how it applies to
certain groups, it's bog standard.
Would you agree that in the grand scheme of what you typically see or think of when you think of a sovereign citizen, or the kind of things you would have on your channel, that I don't fit the typical bill that you would see inside of someone trying to do this kind of stuff? I mean,
well, I just told you where I think there are differences. Is that I haven't heard from a lot of people with this ideology talk, at least not today, about this sort of racial component between blacks and non-whites and whites. But I would say that your ultimate classification as to what you can and can't do by virtue of your categorization of who you are, people, persons, citizens, state citizens, that's standard sovereign stuff.
Well, a lot of the sovereign stuff, like for years, I was doing the whole state national thing, and I was doing all sorts of stuff, and then I even laughed about it in a show, and I said, and then I started reading case law, and then and then everything changed. It's kind of goofy, but then I started focusing mainly on a lot of the case law right around that time period, like 1850 through like 1880 is really where I focused for a long time, because that seems to be where the whole idea of citizenship and all this kind of stuff really kind of exploded, and what did it mean? And so I started really looking.
Civil War, post-Civil War, Reconstruction.
So I started looking into that area very heavily.
A lot of butthurt Southerners didn't.
I mean, if this guy would honestly research it, he might be formidable. But he's fucking Dunning-Kruger.
Like the idea of the Negro having the same rights as all of us, and so they want to try and undermine the 14th Amendment in order to say that it was wrongly ratified along with the 13th and 15th. That's why there's the so-called true 13th Amendment, which was supposed to strip anybody with a bar license of their citizenship. I mean, I've heard it all before. I mean, I think you have to think about why a lot of emphasis of the origination of these ideas come from the Civil War and post-Civil War Reconstruction. But I mean, that's for you to be able to determine yourself with your own research, of course.
Well, obviously, before 57, the idea of citizenship, I mean, most of the cases I've seen, the only aspect of citizenship that anyone's really even talking about is whether corporations can be citizens, and it's always a no. Like John Marshall always said, no, absolutely not. So it just wasn't really a huge confusion, and it's been a confusion ever since slaughterhouse cases to some degree or another. I don't care who you ask. There's a lot of people. Even Clarence Thomas has talked about it. There's always been this confusion. There's entire books written about the slaughterhouse cases and how it fucked everything up, and there's all these different. It's considered the most controversial case that's ever existed, and still here. And why has it not been?
I'd say it's pretty consequential.
No, I didn't say controversial. Controversial.
I know. I'm kind of slightly disagreeing. I would say it's a very consequential case.
Of course, it's the basis of
controversy.
It's the basis of our entire immigration system and everything.
I think Plessy was a far more controversial decision.
But yeah, I don't. It's the day after Slaughterhouse in Bradwell v. State, that kind of opened my eyes, because he's talking about somebody who's just a state citizen and they're not a U.S. citizen, and it's like, well, wait a second. So someone can be just a state citizen and not a U.S. citizen. The day after Slaughterhouse, he's talking about this. So the thing is that it is possible to have one or the other or both, and that's the bottom line.
That's not what it said. But
he said that a person can be a U.S. citizen without being a state citizen. He said that explicitly in Slaughterhouse. So why wouldn't you go the other way around?
Because you're a member of the State of the Union, then obviously you have to be a U.S. citizen.
No, he says in U.S. They say in U.S. versus Cruikshank that a person may, and then the one that you brought up, the court agreed with the girl who said she's both. Mm-hmm. If the plaintiff says they're both,
but you rely,
they're the one bringing the claim.
But you relied on the court's decision in that case, did you not?
Which one?
The Valdenberg, or whatever the hell it's called.
Well, yeah, but the thing is that when he says no white person and blah 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 and all this, it's something he's going off on like a tangent. He's talking like on a more generalized level when he's talking.
So you think that language where they're saying, of course she's both a U.S. citizen and a state citizen, you think that's like dicta?
If someone goes into a court and says that they are, I've never see the thing that blows my mind about citizenship is that I've seen so many cases where they're talking about it or people are talking about it, and it's just one of those things that like whatever the person says it is almost always what's accepted by pretty much everybody in the court. There's never really like they can prove that or something.
So you think the court there's no weight given to that you want to be given to the court saying yes we agree you're both a U.S. citizen and a state citizen. Do you think that's like a flippant line that shouldn't be given any weight?
They don't do that. They just accept whatever it is that the parties say it is. And like for example with diversity, if one party says that they're this and the other party says that it's not, they determine the diversity jurisdiction based off of what the two parties say they are. They're not saying prove it. They're not saying give me a fucking utility bill and prove that, because I can give you a utility bill for a rental property. How do you know that I'm living there? Even if I give you a fucking utility bill, how do you know?
I think you're trying really hard to get out of that one statement by the court saying that you could be she is both a white lady, was both a state and U.S. citizen.
Well, she's telling them that. That's not.
And they're agreeing with you. Not just agreeing, they're saying obviously. It's as in it's
because she's saying it. Obviously,
not because she's saying it, because it is.
No. If you say something or bring a claim, then yes, fine.
Okay.
There's men going into the court saying they're women, and okay, fine. I mean, there's all sorts of goofiness.
So if in my briefing I go to the court and say, yes, the color of the sky at 12 p.m. was a bright sea green, the court's going like obviously, yeah, duh, as an accepted fact in my legal brief.
If it becomes a stipulated fact, if the other party doesn't object or whatnot, it can be considered a presumption under 301. It can be considered rules of evidence. Whatever rules of evidence you're going to be operating off, if there's no objection, then why would they object to a testifying? If the person signs an affidavit under penalty of perjury, now the other party, if they want to object or fight against that, they would need to provide, in a civil case under 301, they would need to provide evidence to rebut the affidavit. But then if they did do so, and the person knew they were lying under oath, now you'd have a perjury charge.
So I would have to prove that the sky was not green on that particular day, or else the court is going to accept it as fact that the sky was a sea green based solely upon what the individual said.
If you have someone testifying on your behalf and the other party cannot destroy their credibility as a witness, and the other party doesn't have a witness, and the one party that has the witness that never has credibility destroyed says certain things like that under oath, and the other party has nothing to really defend against it, then yeah, it becomes stipulated fact in the case.
I know, but I think we're at an impasse here.
Well, you just said yourself, getting into a courtroom is going to be new for you, so you'll learn more about the rules of evidence when you get in there. I mean, it's something I'm really involved in.
I've already been in courtrooms before, but yeah, I'm well aware of what the rules of evidence are and laying a foundation and so on and so forth.
Okay.
So, all right, it's 7:30 where I'm at.
Are we done? Thought this was interesting.
It's the air into cold.
I'll probably get struck for this.
When I blow air into this device, it separates the air into cold molecules that come out of this end and hot molecules that come out of this end. See how the hot end can melt gallium? It doesn't use electricity and there are no moving parts. Isn't that crazy? Maybe you've seen one of these things before. It's called a vortex tube. But look, I managed to get one made.
Be interesting to see if Flatswood can explain this.
Of glass so that we can see what's going on inside, and I cut one in half, so we really should be able to figure out how these things work. I love vortex tubes because straight away it feels like we must be violating some law of thermodynamics, you know what I mean? Like obviously fridges do it, they make the inside cold and the outside hot, but that's like a whole complicated machine. This thing just separates air into hot and cold. How is that possible? Well, a famous scientist called James Clerk Maxwell also thought about separating hot and cold molecules. He imagined a little demon at the opening between two containers of gas. Like a bouncer, the demon only lets hot molecules pass through in this direction and cold molecules in this direction, until eventually all the hot and cold molecules are separated. But that would violate the second law of thermodynamics. You can't just sort hot and cold like that without expending a whole load of energy in the process. That's why your fridge stops working when you unplug it from the mains. But this thing isn't plugged in anywhere. It feels like this is Maxwell's demon in mechanical form. But it can't be, can it? If we can get our heads around the working principle of a vortex tube, we should be able to answer that question. The first thing you'll notice is that the inlet tube is off center. So when the air enters the main tube here, it forms a vortex spinning counterclockwise. This wall here prevents that spiraling air going in this direction. So you end up with this twisting corkscrew motion in this direction. You can see it for real here where we've added particles into the stream. When this vortex of air reaches this end, there's a tiny gap around the outside edge and some of the air escapes. The rest is forced into the middle of the tube. Angular momentum is conserved, so it's still spinning. So you've got this second vortex traveling back down the tube through the middle. This inner vortex lines up with the hole in the wall, so you have another stream of air coming out this end. This is the cold end, and this is the hot end. But how? Well, I mentioned earlier that angular momentum is conserved when some of the air moves into the center of the tube. And you might know from ice skaters that they spin fast.
Anyway, I'll get struck if I show any more of this. Probably what I'll do is I'll put it in here and let you guys go look at it. It's pretty fascinating. Kind of blew my mind. So anyway, thanks for watching, guys. We'll talk to you later. Be seeing you.